Made pigeon. My lord, basically, for compression of natural gas, this particular contract was awarded. And there are 8 number of locations. Now, original NIT is of
This is
24
called gas, what we call it?
compressing. my lord.
Compressing.
Just to tap the natural gas and put it in the pipeline. These are basically called gas compressors.
Yes.
Now, my lord, this NIT was issued on 24/1.
Today we are considering the interim period.
Yes. Then, my lord, it was followed by letter of award on 17/5/21.
Just before that, Mr. Dotto, NJ Dotto. Your case, I have gone through it. Ultimately, we will have to complete the argument on the appeal. You have completed your part.
My submission is that, madam, I have overstayed, madam.
No, your overstay will depend upon the determination made in the merit. Prima facie, we are not satisfied
That's
for
why,
the
madam,
purpose of bail.
That's why I asked.
So therefore, we will complete the hearing and keep it for delivery of judgment.
So otherwise.
So
madam,
therefore, intimate Mr. Das, he was supposed to address his argument. Okay.
Today it is listed for the bail.
If necessary, we'll fix it on second.
And the bail can be considered. today.
No, we'll consider everything because I have seen my note. Everything is argued. All points were taken note of. Instead of keeping it piecemeal, we have already spent 3 days. So why is the otherwise again some judges will have to exercise the same thing. So we'll fix it on second. You inform Mr. Das. Yes.
Yes. 2 তারিখ হেরি অক্টোবর হেরি জুলাই আগস্ট 2 আগস্ট ফ্রাইডে
First or second, either.
Second.
My lord, it was followed by a letter of award dated 17/5/2021. And by this, my lord, a period of 300 days was given for mobilization.
Now, just for a clarification, you approached the this court initially
Yes,
by a writ petition,
yes,
wherein you sought for a stay, which was declined. Now, thereafter, however, an observation was made that they can decide your representation. That has been rejected. That is the second case.
second.
Now, you are seeking similar.
My lord, what had happened?
Just give.
What happened initially, there was an NIT.
Mm.
That NIT is of 24/1/2020.
Mm.
Pursuant to that NIT, award was given to me
Mm.
on 17/5/21.
Mm.
Now, there were extension of time were given.
Mm.
Eventually, my lord, in respect of 5 compressor, everything was ready.
Mm.
But in respect of 3, there was some time was required.
Mm.
In respect of 2, my lord, actually, it involved taking land from tea garden.
Mm.
Because these locations were in tea garden. So for conversion of tea patta to that is beyond my control. They are also cognizant of the fact. And in respect of one particular, location, there was opposition from the members of public. Na? So this is the position. But in respect of 5, everything was ready, Miller. They have given the photographs also.
Now,
No, I'm coming to that. Now, thereafter, when things were going on, then they terminated our contract.
Mm.
Against that termination, we filed representation. Then they restored our contract, extended us. So things were going on.
And prior termination, there was an NIT,
Huh.
which later they abandoned.
And there was also another NIT which they themselves abandoned.
okay,
No,
that,
last
that,
time-
that NIT I was asking
Ah,
about,
no,
because there is
no,
a
last time-
reference of that NIT in the earlier order.
No, in the thereafter, my lord, another NIT was issued
Mm.
where they proclaimed that they will do the work themselves.
Okay.
Now there is an affidavit.
Hmm.
Now the question is, when you have come up with a stand before the honorable court, when we raised our grievance, they said, no, we'll ourselves do. Now why have you issued the third NIT? You made a solemn statement before the honorable court. If the lordship would kindly come to page number 348 for a moment. Para 13.
Now, what will be your interim prayer today?
My interim prayer is, my lord, this NIT which now they have floated,
Hmm.
that should be stayed.
Okay. Now, what is the last date of that?
Today, my lord.
Today,
Now please come to page 348, my lord.
348.
Yes, para 13 on top.
340.
This was their stated stand before this honorable court. Yes,
Yes.
that the deponent begs to state that pursuant to termination of the contract with the petitioner, the proposed project that was to be undertaken through the petitioner has been completely abandoned, and for said operational requirement, OIL took up a policy decision to carry out the said work by in-house approach, and for the same, and pursuant to budget allocation, OIL has proceeded to undertake said work by placing purchase order, and thus now OIL has moved far ahead from the situation as it was existing around the time of termination of the contract of the petitioner. There is now no question of reviving the contract work as was given to in the past to the petitioner. So, my lord, this is their case. If this is your stated stand, how come you have issued an NIT now?
Now, next question will be how that will be violation of any of the right of yours.
No, yes, I'm coming to that, my lord. My lord, to appreciate this whole case, one particular clause in the standard bidding document is very necessary, my lord.
Yes.
Please come to page 133.
133.
Yes.
Just a minute.
As per the original work order, my lord, this was the clause.
133. Yes.
Kindly see, my lord,
Hmm.
commissioning of the compressor, the last clause.
Hmm.
The commissioning of the compression service should be completed by the contractor within 300 days from the date of issue of letter of award, that is 17th of May 2021. Now, this is important.
Hmm.
The date of commencement of operation shall be considered from the date on which first compression service is successfully commissioned. So, my lord, there are 8 locations. The moment we successfully commission one compressor, then in terms of the contract agreement, it will be presumed that the contract has commenced. Am I clear, my lord?
Yes.
Now, my lord will kindly come to
Hmm.
page number 259.
59.
My lord, before appreciating the facts, before I take your lordships to page 59, on 16/7/22, my lord, the OIL terminated my contract.
On
16/7/22 at page 255. Then, On
250,
the lord.
250, 255.
yes. So, my lord, it is a recital at page 256. 5.0. Your
minute,
inability to provide services.
5.0.
5.0, yes. sir. Your inability to provide the services even after a lapse of more than 4 months from the due date of scheduled mobilization is a breach of contractual obligation. Therefore, instant contract shall stand terminated wholly on expiry of notice period of 15 days. Then, my lord, this was, then, my lord, at next page, na?
254. They have extended.
And before that, at page 254, my lord, it was extended till 15/8/22. At page 254. Then, my lord, at page
Just a minute.
number 257,
Where is the extension?
extension is at 254 meter.
Ah.
1.0. Has your lordship got it?
Yes, sir.
Reference to your above letter requesting for mobilization time,
Okay, 15.
extension against
15,
contract, so and so, so and so. We are pleased to inform you that validity of mobilization period against the contract has been extended till 15/8.
Mm.
Then on my lord 16/7, they terminated. Then please come to page 257.
Yes.
They kept this termination, they withdrew this, my lord,
Hmm.
by 257. Am I clear?
Okay.
Then my lord will kindly come to page number 258.
This is withdrawal, is not it?
Yes, withdrawal.
Withdrawal of this
16/7.
16/7.
Yes.
Yes.
252 B.
252 second extension.
Yes, then
Yes. Then come to 258, my lord. Again, they extend the contract up to 31/23. 31/1/23.
Hmm.
My lord, they're oblivious of what is happening in the ground. They extended it up to 31/1/23.
then
Then most important is 259. There was a minutes. Now please come to 4
Hmm.
at page 259. Pre-commissioning inspection notice by Messrs. Debbie for tree installation will be given by 22/23 and commissioning of 3 installment will be completed by 28/2/23. So a consensus was arrived at. Now, my lord, here there is a question of, my lord, conduct is also there. Now, by conduct, they are extending the contract. Now, can they stick to their original clause? Now, 4, pre-commissioning inspection notice by Debbie for tree installation will be given by 22/23 and commission of 3 installations will be completed by 28/2/23. At page number 261, my lord, we write to oil.
we can ask him to go, leave for a
It
time
will
being.
take some time,
Minutes, let's say,
15-20 minutes.
15, 20.
My lord will kindly come to page 21,
262,
261.
261.
This is our mail letter dated
Hmm.
22/23
Hmm.
because they said we have to intimate the date.
Hmm.
Please come to the last para.
Hmm.
In Bagzan site, we are ready for commissioning of the compressor on 26/2/23. So you are requested your good office to kindly give us clearance for connecting the pipeline to the hookup point and inform us the date between 22/2/23 to 25 to work at your convenience. So we inform that as far as Bagzan site is concerned, we propose to connect the hookup by 25th. So please make the necessary arrangement. They never, my lord, responded to this.
Then thereafter,
They terminate.
where is that
Now, my
place?
lord, I'll just show some photographs. If your lordships will kindly come to page number 301.
Yes.
Now, if your lordships would kindly come to the extreme right-hand side below,
Hmm.
lordship must have seen that this pipe, there are 2 pipes
Hmm.
with loose ends.
Hmm.
Now, all that is required is they will just hook up this pipe so that, my lord, the compression process can start. So that was left to be done. So we informed them we are ready to do it.
Mm.
That is why, my lord, page 133 is very important. The moment one compressor is commissioned, then, my lord, the work will commence, which they did not do. So is this not arbitrariness, my lord? End of the day, my lord, kindly see. We are prepared to do the work even today at that rate. Now, today, if another contractor is to be engaged, there will be escalation. Now, by their own showing, my lord, in the new contract, they have given a mobilization period of 1 year, 6 months. That means 18 months. Whereas if it is given to us, my lord, maximum given.
3 months we can do it.
My lord,
Eight.
as far as 5 is concerned, within a week, we will do it. And regarding 3, we will do 3 months only. Now, my lord, we appreciate, my lord, the constraint of a 226 code to proceed to interfere in a matter of this nature. But will your lordship not look into the arbitrariness? Some officers, they do not decide what public interest is, my lord. Some officers that sitting at the Oil India headquarters, they're hardly oblivious of what public interest is. It's a public law remedy. In Tata Cellular, my lord, recently there is a judgment of the Supreme Court. I think that MP Power, I think it is a judgment of
My Lord Justice Kurian, Joseph and Rishikesh Roy,
no, my lord.
MP Power.
MP Power. I think it is.
That says that even in non-statutory contracts, these are the conditions
Yes,
you can.
MP Power.
MP Power.
My lord, Joseph and Rishikesh.
Rishikesh.
Yes. Lordship has seen, in between there was a train to, my lord.
This
bring in
is a
the
Senji
restraint.
trend. This is a Senji in the trend.
Change it up. In fact, my lord, what was laid down in Sri Lanka Vidyarthi has been reiterated. Therefore, even after entering into of the contract, if there is arbitrariness, as was pointed out in Tata Cellular, now that power is revived. In between, my lord, there was some gray area because of some judgment, as if these are matters basically to be left to the wisdom of the authority. So, I mean, if not in so many words, a view was sought to be taken.
Practically, non-statutory contracts were excluded from the purview of judicial review.
Yes. To put it,
The only
to put it
change,
more appropriately.
only change in is that MP Power.
Joseph and Rishikesh,
Yes.
absolutely correct. I was telling my learned friend. Now, my lord will kindly see, by your own contract, if I hook up one, then my contract starts coming. It is commission. Then you can't resort to this power. My lord, there are certain activities which are beyond our control. Why do we call act of the God? The act of God is not required. If everything is within our hands, then these expressions would not have evolved in the judicial discourse. So my humble submission is, my lord, now this was the position in terms of page 133. I would have commenced my work. My lord, I have taken 23 crore loan from Netfi, my lord. Now, will this money go down the drain? Am I so helpless? Is this not the forum I cannot hesitate my cause? Now, my lord, 34 crores I have spent in all. So what we are saying is, my lord, it's a question of balancing the equities. Page
Page 216.
269, no?
That's 2 days before the examination.
And my lord, I'll just show another communication at page 269.
Just a minute. Please.
269, itu কিন্তু kami আছে, কিন্তু যত আমি কামটো আৰম্ভ কৰিব পাৰো। Now, my lord, the termination notice is dated 8/10/23, my lord, just 2 days before, kindly see, on 8/4/23. Now, there is a location called Hati Ali, where we say, my lord, there were objections from the public and all.
269 something custom and all.
Yes. No, kindly see who is writing this letter.
Yes.
Oil India is writing. Certificate for import of goods in terms of customs notification. Goods imported for petroleum operation undertaken in the area specified under the petroleum exploration license, mining, etc. This is to certify that the goods being imported under Annexure A are required for petroleum operation for execution of the project as per the detail mentioned in Annexure B. In accordance with serial number 11 of GST circular dated so and so, the original import essentiality certificate issued by oil is sufficient and there is no need for taking certificate every time on interstate movement of goods in the same company, stock transfer as long as the goods are same. This certificate is valid for 6 months. We all know, my lord, from Mundra port, if a consignment is to reach the state of Assam, it will take at least 45 days by truck. On 8/4, my lord, they say this is the consignment which is coming for our purpose.
Where is the subsequent termination?
Yes, at page number, my lord, 274. Which we challenged in the earlier round of litigation. At page 274.
Now, how do you deal with this order of 23/6/2022 in the context of the present petition? Where certain observations were made, certain findings were given that this is a non-statutory contract, therefore arbitration is there, so therefore we are not inclined to pass any interim order.
No, my lord, my
How will
humble
you
submission.
deal with it?
No, I got to get it, my lord. Now, my humble submission is, my lord, in case of a non-statutory contract.
No, that's fine, but this is an order. In the earlier proceeding arising between the same parties on the, even if this court
no, no,
thinks that
no, it-
these are, this is these.
my lord, this aspect now which has transpired,
Hmm.
that page 348, para 13, the stand,
Hmm.
vis-a-vis that, why not, my lord?
No,
Now, there your stand was,
this fact were available on that day also.
No.
Whatever you have argued.
no, but, no, my lord, now my case is more emboldened because of the new NIT. There they said, now we will do of our own. There was no NIT then.
No, at that point.
After this termination,
Hmm.
after this
No,
termination.
there was an NIT
Yes,
at that stage also.
no,
You
that,
sought for an stay,
no, there's, there.
but they withdrew. That is a different issue, but stay was not granted. Just correct me on facts.
Yes,
That's all.
no, correct. No, my lord,
Ah.
if that is the position, my lord will kindly come to 2 orders which were passed in this proceeding. No, I've got it, my lord. I have taken order. Take, I mean, please come to my lord, page 330.
330.
Yes. Three 330.
Hmm.
Now the matter reaches to what stage?
Hmm.
It starts at 329.
Hmm.
Now please come to 330.
Hmm.
List these matters on 2/5/24, on which date Sri so-and-so, learned senior counsel shall obtain instruction with regard to status of air compressor to be fitted in Bagjan, Balimara and Bekulijan, which the submits can be completed within 24 hours. In respect of Sabuan Barekuri, which is submits can be completed in 1 week. Well, they came up with some absurd answers. The court was inclined to give a relief. That's why court has posed this question. Because we said in 24 hours we'll hook up these two, and for the others we'll require week's time. This was the stage. Then my lord will kindly come to next page, page 333.
Hmm.
Another order.
Hmm.
Last para. The order dated 29/4/24 needs
This
to be
matter still
clarified.
part heard.
No, it was. It has been released. Yes. Needs to be, inasmuch as the observation made therein that operation of the air compressor in Bagjan, Balimara can be completed 24 hours, and in respect of Sabu and Barekuri in a week's time has been made by, actually there was, while recording the order, my lord,
Okay, there is
some
some mistake.
statement which I made was put into the mouth of my learned friend because of the typographical error that was corrected. So my lord, court went to that extent. It was at that stage that affidavit was filed, where they came up with the plea that they will do in-house, they will offer own. Now, for some reasons, my lord, we need not disclose. The matter was almost, my lord, half of the dictation was also given. Because the honorable judge himself told us, my lord. But then it was released. Whatever it is, that's a different issue. Now the question is that, now lordship, the position before your lordship is, we are alleging at least, that there is arbitrariness on their part in dealing with our life. My lord, these are all very highly technical jobs. Nobody is perfect in this world, my lord. End of the day, kindly see, my lord, supposing tomorrow the impugn NIT which are under challenge is given effect, what will happen to me? I'll go back to the street. The 34 crores as I have spent, that will go down the drain. Is it such a situation, my lord?
That lands belong to whom? Those where you have installed those projects.
No, as far as the five sites are concerned, we have purchased.
Hmm.
But tea garden land, we cannot
Okay.
outrightly purchase.
There is a change of policy in between the contract.
And in between, my lord, once the contract was entered into, there was change of policy of oil also.
Government.
Sorry, government. Who my lord, the allotment of land.
I think Deputy Commissioner had the information.
Earlier, my lord, Lordship knows it was deputy commissioner who had the power. Now it is the state cabinet who has to deal with the right. Now here is a case.
Earlier, it was the
Respected
Department of
Deputy
Revenue.
Commissioner.
No, Deputy Commissioner will send this to the revenue. Revenue will give finally
Now by the cabinet.
by the.
Now, my lord, here is a case. A contract we have substantially performed. Now, yes, there is a clause in the contract. Time is the essence of the contract. But by your contract, have you not waived these rights? To insist on the, you have extended thrice. Twice expressly, third by necessary implication. When you said the consignment is coming, our goods are coming, writing to the customer, are you not extending the contract by 6 months? So, my lord, here is a case whereby your express conduct, you have decided not to insist upon a right flowing from the non-statutory contract.
So what will be your argument as regards that? Just summarize your argument to that. You will argue other points.
Yes,
So far relating to the interim order passed on 23/6/2023,
yes.
where these points were deliberated, and what is the sense of situation that we can ignore this order?
Change of the situation is, my lord,
Hmm.
on 23/3/23, the stand at page 348 was not before the court. Because that was an affidavit which was filed subsequent. No? That stand was not there. Then court was informed that we will do of our own. At a later stage.
Yes,
But on that day, it was not there.
not there, but even if it was not there, the view expressed was what is, of course, this is an interim. At the same time, we are also considering the interim, not the final determination.
My submission, if you may, lord, whether an interim order, even if it is passed or if it is declined, that cannot operate,
No,
operate.
we are not on that. In an other case, that will not at all. That cannot be a ratio. But when in the given facts, where a continuation of litigation at one stage injunction was refused on these grounds, whether similar injunction can be granted at the later stage.
Kindly see, that is not an express refusal, my lord.
Page 28.
It was an express refusal.
No.
Express refusal.
Finally-
Therefore, this was an express refusal. Whether this went to the,
No, please come to page 288, my lord. 288,
paragraph 13, 289.
13. একটু মনে সহকারে, মনে যাবে, no? Excellent. That's right. Having considered all aspects, the prayer for interim relief regarding keeping the termination notice in abeyance
You are in the same
and
similar
I'm coming
situation at
out,
this
and
stage.
stalling the bidding process initiated by in misdemeanor found to be inappropriate. Further, having considered all aspects and the consequence, the petitioner is likely to be visited with in the event of gas compression services at 8 number of locations as initiated by NIT are operationalized. It is observed that respondents shall give final consideration to the representation submitted by the petitioner, so and so, by taking into consider facts highlighted in the reference before finalizing the bidding process initiated by NIT. It is expected that respondent oil by giving consideration shall pass reasoned order. So, my lord, yes, there was an element of refusal, but at the same time, my lord, the authorities
That
are
is-
directed to consider. Now-
Consider your case. That has also been rejected. That is also under challenge.
That is under challenge.
That is under
That is
challenge.
under challenge. So
But
in
whether
that-
this forum will be a challenge
No,
of
madam.
that is a question.
No, madam.
These are the things which are, see, I'm open to everything. Arbitrariness, of course. My principle is that it cannot be reach court jurisdiction
Cannot
or
be
its
taken
power
away.
taken away by all these things.
Yes.
I will go by the judgments, the recent judgment.
Yes.
But thing is that in this case, there was an interim refusal of interim order in a similar situation.
There was a refusal as well as a direction also. Refusal
So,
was.
yeah, now at this stage, there is no scope for further direction, even if it
What
is
I'm saying
refusal.
is, having refused, but refusal was a conditional one, Mike. The refusal was on account of the fact that I am remanding them, I'm also directing them to consider your case before it is too late. I think my humble submission would be, Lord, Lordship will have to construe the, effect of 23-6 order in that line. Yes, the refusal was on account of the fact, or rather it was a conditional refusal. It was not in, my lord, express refusal that no, we are satisfied. You have not made out a prima facie case. We are not inclined to do. Kindly see, my lord. So therefore, my humble submission, it was conditional. Now the subsequent part, if they have, because of their subsequent, conduct, will that element of arbitrariness not fit in, my lord, to give your lordship the jurisdiction? And this additional affidavit which they have filed, which definitely furnishes us an additional cause of action, my lord. When they say that they would like to do the work themselves, now by spending public money, they would like to do it through some other agency. And my lord, kindly see, now they will have to wait for another 18 months. They'll have to spend more money. I'm sure, my lord, the cost of the project would go up now.
See, these are the observations. Kindly come to paragraph this. Mr. Sharma, page 289.
289 million.
It is
Yes.
further brought to the notice of this court by Mr. Sharma that in clause 14 of the contract, it provided that if any dispute, difference, question, disagreement arises between the parties, so and so, this, contract breach thereof, which parties are unable to settle amicably, the same shall be referred to arbitration by the procedure, so and so. Agreement invoking earlier giving due notice. I find force in submission of Mr. Srivastava's mechanism.
My lord,
So what are you saying is a mechanism already there. These are the things you will have to address on this to have an interim order.
No. Yes, I'm prepared to do that, my lord. Now, my humble submission, subject to what your lordships may say, is this observation in para 12 stands diluted by para 13 later part. My lord. Then, my lord, if I am to go to arbitrator, then where is the question of I again approaching the authority? Now, the honorable court having said that there is a scope for arbitration, if the matter would have ended there, then it is okay. Then directing them to dispose of the representations expeditiously and by refusal thereof, would it not furnish a fresh cause of action? Well, that's why I'm saying, my lord, here as far as All India is concerned, there is an abandonment on their part to rely upon those clauses which says that it has to be done in so and so period by their conduct, including conduct of extending the conduct. My lord, when we say there is waiver, what do we mean, my lord? In my humble submission, what we mean is voluntarily we decide not to rely upon the clause which governs the rights and obligation of the parties. Am I clear, your lordship? My lord?
Yes.
The moment I extend you the contract, that means that time is the essence of contract. Now in arbitration law, that's the position, my lord. If there is a provision for extension of contract, then the clause that time is the essence of the contract, that may not be helpful. That's what the Supreme Court has said recently. Now here, the moment you give us 2-3 extension, are you not, voluntarily agreeing not to insist upon those clauses? If that is the position, my lord, giving us some time to connect the hookup, will it create a situation where, my lord, there will be a failure of justice or something? Is it a rocket science, my lord?
Yes, let us hear Mr. Chutu.
Here is a yes. I know we are not very ideally suited, but then, my lord, even in this, my lord, thorny path, there are still hope, Milord. At least, Milord, that arbitrariness aspect, Lordships will certainly look into it.
Definitely.
Either way.
Yes, let us hear for some time, Mr. Chaudhary.
My lord, your worship has seen the order passed in the earlier petition refusing the interim order. Then there was a direction to consider the case in the light of the submissions made in the representation. That was also rejected. That was, my lord, challenged in 5309 of 2023. And while moving that petition, my lord, even the interim order was not raised. Your lordship may-
Lordship's kind permission, can
Yes.
I take it? I'll come with that.
because in view of the order passed by Honorable Justice Chaudhary in the first case, my lord, when the representation was disposed of, rejecting their prayer, then the second writ petition, 5309 of 23 was filed, and they knew that there will not be any interim order. And if your lordship kindly sees the order dated 14/9/2023,
Hmm.
in my lord 5309 of 23,
In the writ petition?
Yes,
Or
ma'am.
anywhere annexed? No.
it has not been annexed.
Yes.
There, my lord, only notice was issued.
Mr. Bhatta, you are appearing for whom? Net fee. Which order?
First order, it should be first order, 14/9/2023. I've given a copy, my lord. Your lordship may see the copy. Issue notice making a returnable by such and such date, Mr. So appears. All the respondents are duly represented. Respondent number 1 and 2 shall file their affidavit in opposition without fail. My lord, the interim order was not raised at all also, my lord. So, my lord, the question of passing any interim order did not arise now, my lord. The submission of my learned friend is that, my lord, in view of the affidavit that we have filed. Subsequently, some new facts have been brought in, and that's why, my lord, his case stands on a different footing. Now, your lordship will kindly see what is the NIT which has been challenged. That your lordship
What is
find,
the position NIT issued on, is this in impugn NIT issued on?
this is 5/7/2024.
And today is the last date for
Yes, ma'am.
submission.
Yes, ma'am.
And what is the next process?
Next procedure, your lordship will find, my lord, at page 400.
Tell us,
The
tell us.
bid end date is 37. Bid opening date is 30th/7, that is today, my lord. And technical clarification 10 days, some time is there, my lord, for finalization. Now, if your lordship kindly takes up the impugned, my lord, NIT at page 400,
Yes, phase
page 400.
400
That is the NIT that has been challenged
in the present
in
process.
the present procedure.
Yes.
Bid document, this is dated 5/7/2024. Your lordship may
This
come
is
to
page 300, annexure 33.
Annexure 33. Item category,
Bid ended 37.
yes, ma'am.
Bid opening 37. Bid offer validity 120 days. Okay. 1 year, 6 months.
Then your lordship may, my lord, see the item category. What is the items in respect of which the NIT has been floated?
Where do we get that?
At the page 400 itself, my lord.
Huh.
1, 2, 3, 4, 5.
Document
6,
required
7,
from
8.
seller, startup exemption. Where?
Office name and thereafter item category.
Okay. Item categories.
This
Okay.
is the, my lord, the items in respect of which this NIT has been floated.
11 numbers of locations.
Custom bid for services, installation of gas compressor units in 11 numbers of location, reciting of gas compressor package, installation of natural gas production equipment and other piping modification jobs inside gas production installation.
Okay.
Now, my lord, I'll take your lordship to the affidavit that has been filed, which your lordship has already read, but one paragraph I draw your lordship's attention to. The affidavit,
Page was
my lord, affidavit starts at page 336.
336.
It is an additional affidavit
Just a minute. 336.
to bring on record the status of 11 numbers
Just a
of gas
minute.
compressors.
348. Yes. 336.
336.
Which paragraph you will
My lord, this affidavit is regarding the position because there was an order of the court. The court wanted to know the status. Now, your lordship may kindly come to page 347, paragraph 12.
347. Yes, paragraph
Paragraph
12.
12.
Yes.
The deponent begs to state that in the interregnum period, HAZOP studies for all these sites was initiated on 29/9/2023 and completed on 9/1/2024. Further, new land was acquired at Bagjan on 10/1/2024. Parallelly, after finalization of technical specification, purchase requisition were raised and subsequently tenders were floated for different equipment, including gas compressor package and air compressors.
Mm.
So, my lord, we had already, before the filing of this affidavit, we had issued, my lord, NIT tenders for gas compression and other equipments.
But this was withdrawn.
This was not withdrawn now. This is not under challenge. Now, present NIT which is under challenge is,
According to you, the present NIT is relatable to this paragraph 12.
yes, my lord.
This is your case.
Yes, my lord. And this tender for including gas compressor package, gas compressors we have, my lord, purchased through, my lord, NIT.
Mm.
And after they have come, my lord, they are to be installed. And for installing that, my lord, minor works are there. That is what the, my lord, present NIT
Now,
is for.
according to you, the new NIT is not built, own and supply. According to you, it is an NIT which is, you have gone by your affidavit, you have issued NIT for the, only for the purpose of installation and running.
My lord, to clarify,
Mm.
we have already floated tenders for gas compressors and allied instruments.
Mm.
And my lord, after that, the present NIT.
Therefore, your stand in the paragraph 13 is relatable to paragraph 12 in a sense that we have procured the equipments through tender
Yes,
and will do on its own, and now for completion of this
the
work,
civil work.
civil completion of this work, we have issued the NIT. This
Second
is your
NIT.
case.
Yes, my lord. So, my lord, the foundation
Mm.
has not been challenged. Foundation is the, my lord, this tender
Mm.
procuring the gas compressors.
Mm.
And they have challenged the, my lord, superstructure. Your lord, my lord, I had obtained some instruction, my lord, may I read it?
Mm.
Contract number 6115517, that is the earlier contract,
Mm.
was awarded to Devi Engineering for hiring gas compressor services on build, owned and operate basis, wherein the party was supposed to build gas compressor stations in the vicinity of all existing installations, operate them and provide services of gas compression to oil for the construction contractual period. The ownership of the gas compressor remained with the contractor and the oil sought only the services of the compressors. Tender number, this is, my lord, the present tender, has been floated for hiring of services which include piping modifications inside gas production, installations for gas compressor packages and piping modifications for relocation of the old gas compressor packages to another gas compressor station due to change in gas production profile, and also for maintenance of jobs and other installations of oil. The services are auxiliary services required to prepare the sites for installation of the newly procured gas compressors of oil. That was the earlier tender, which was not challenged. The scope of work of both the cases are different and not comparable. Some of the locations in both cases may be similar, as both the contracts are required to cater to requirements of gas compression stations of Oil India Limited. Tender number so-and-so is floated as an open tender through GEM, and the petitioner is free to participate in the same. The earlier hiring compressor service on the build, own and operate basis was for services including lands, equipment, pipeline at 8 locations for flare reduction. Please note that as per GEM tender document, the end date of the bid on the challenge, that is NIT number such and such dated 5/7/2004 is 30/7/2024 today, which is floated for piping jobs and piping modifications for installations of in-house gas compressor units for flare reduction. As you are aware, the fact that oil is going for in-house gas compressor units at 11 locations. The purchase order for direct equipment has been placed. When the equipment reach the site, the same needs to be connected through pipe by laying new lines, modifications of the existing pipeline. The tender has been raised for these piping modifications jobs as well as other jobs ambitious for production of natural different installations. And NIT number so and so dated 5/7/2024 will be used in the above mentioned 11 number of locations as well as other production installations of oil. So, my lord, if your lordship, my lord, permits, I can also give the scope of work of the, my lord, present NIT. 124. The earlier NIT, the scope of work is at page 124. And this is a different work altogether. And this is also subsequent to the, my lord, earlier tender for obtaining the gas compressors in-house. Your lordship will find, my lord, clause 2, piping, fabrication and installation. Then, my lord, serial number 3, civil engineering job. So far as, my lord, gas compressors are concerned, my lord, we have already procured them by a tender process which has not been challenged by the petition. The scope of the work of the earlier tender,
Just a minute.
so, my lord, these two have no relation at all. When they did not challenge, my lord, the NIT tender for procurement of gas compressors, now for installing it, the subsequent NIT that cannot be challenged. The earlier work was, my lord, as your lordship has noticed, my lord, on BOO basis. That is your property, you will run it. Now we have decided that we'll do it on our own, in our own land or procured land, and we have purchased the, my lord, the gas compressors. Now it is the civil works for installing them. That is the tender undertaking. And, my lord, that we'll do it on our own does not mean that, my lord, we'll do it with our technicians. We have to get the, my lord, the equipment. Even, my lord, the gas compressor we do not build. So we floated tender for that. That has not been challenged. And our case, my lord, all through was that, my lord,
Yes.
all through our case, my lord, the matter was in fact heard on the 3 days. My learned friend has submitted before lordship, my lord, the half of the order was also dictated. Then, my lord, if your lordship goes to the video recording of 11/6/2024, your lordship will find, my lord, why after spending so much of time, my lord, the court had to release it from court.
Let us not use that evidence. Not admissible.
My lord. And our case was that, my lord, it is a matter you can go for arbitration. And that is also observed by the, my lord, the order when rejecting the, my lord, the interim
Yes,
order.
Professor, what you say about, they are saying the scope is different, totally different. See,
Scope is
prima
different.
facie that seems,
Scope is different, and, my lord, this is consequent to the, my lord, the earlier tender, which is not on.
because this is not BOO. It says you supply these materials, these are the civil works. So they will do it, but this is supply and execution of the contract works. Same seems, it seems.
My lord, if your lordship will kindly appreciate that the civil works has already been done in all these 5
No,
locations.
we understand, we understand. Your case still would be that whatever we have done, why you need to do it on your own?
Don't let me clarify, my lord, just for a minute, my lord. The work they have done in the, my lord, locations, we are not touching that, my lord. That we have abandoned. We have got our own land of our oil land and, my lord, some land procured from the state. And we have done it separately. It doesn't have any correction or connection with the work they have
That is
done.
what you are saying. You are
No,
saying
but-
now
but
they
the-
will build, own and operate. For this building purpose, they are seeking some materials and civil work contractors. This is
And-
your case. This will be now built, own and operate by the oil themselves. But for the execution of this construction work, they want some contractors, as you might have also used some contractors. This is their case.
If the 8 locations, if your lordship will see, it is not the, okay, the location which we are using, it is the our land which we have purchased it.
Mm.
They are doing it in their own land, but in the same location. There's 8 locations and locations are same.
11 locations, they
Yes.
might have some 2, 3 at this.
Yes, 2, 3 additional location. But if your lordship will kindly find page 367 onwards, what are the
Understand,
purchase
understand.
orders?
There will be another issue. Suppose your argument made by Mr. Chaudhary, we accept it and we say that this is arbitrary. Now, due to change of time, you have to answer the question that on the date of filing of the affidavit, they made it clear that we are procuring it and there was no stay order. In the meantime, they have procured these materials.
No,
Now, who
It
will,
is not procured. That is what my lord, page 367 onward. If your lordship will see the purchase orders, these orders were placed.
no,
The delivery of the materials
Are
and the
not there.
payments are to be yet to be done.
no, this is for, yes, materials are yet to be done.
Yes.
So you want to say that that should be, so their policy of having their own indirectly are under challenge.
No, if your lordship kindly
view
find
of
from
your
page
tender.
367.
Huh?
From page 367 are the purchase order which they have enclosed with that additional affidavit.
Mm.
If the date of the delivery of this purchase order, if your lordship will see, it is all on September 24, December 25. It is no purchase, no materials has yet been procured.
Understand? Even if not material is procured, so their affidavit, stand on the affidavit that we are doing on our own, still holds the field.
Hello.
That is what I am asking.
Yes.
So therefore, the situation that no, they are now trying to give it to a party who is similar to us within 1.5 year, whereas the already a asset has been created. Therefore, this is arbitrary. That argument may be attractive, or in a given case, we may also accept this because ultimately it's a public money.
Yes.
But they took us then at one position, say, yes, enough is enough, we are doing on our own. Now, they have issued tender in terms of that policy. That policy is not changed. If that is not changed, then the earlier interim order is there. All these observations are there. Admittedly, this is a contract. So how can we pass an interim order?
My lord, if your the earlier NIT,
Mm.
well, in fact, if your lordship will see the date of the NIT,
Mm.
that itself was issued after the first extension. When there was an extension, they issued an NIT.
So that they have abandoned.
Yes, that they have abandoned after the challenge was put to that
So
NIT.
can you, in a read proceeding, question the wisdom of this employer of their decision to think that, okay, these contractors, they cannot execute, this will creating us loss, assuming for a moment, that may be their opinion.
Right.
So therefore, let us do on our own.
Right.
And therefore, let us procure these materials. We have already procured our land. We have already stated. So their policy remains, Mr. Chaudhary has argued that no, by virtue of this affidavit, there is a change of situation. Now that is also gone. If that is gone, can we pass an interim order?
So if your lordship will see the work which was executed by us,
Mm.
your lordship has seen page 269.
Mm.
We, in the minutes, they fix the
No,
time.
that deed
Hello.
is there no dispute on that.
Yes.
Your case is that, in fact, you yourself has said that we will extend to this. Thereafter, you invoke, and the clause says first installation will amount to the operation, and you have not allowed in terms of this notification. So therefore, this can be a subject matter of a dispute redressal forum which has been observed. That remains.
That clearly
That remains.
establishes. That clearly
Understand,
establishes.
this argument was exactly, if you go through the judgment, all these arguments were there.
Right.
How will you suffer? Everything was there.
Right.
Despite that, interim prayer was rejected, said that this is not a case.
Right.
Now, can we pass an interim order? It was not taken to the higher ups. No division bench.
Correct.
So if no division bench, on the same, we are not saying that any interim order will be binding upon us,
Correct.
but it is a interim order relatable to the same transaction, same between the same parties.
The interim order earlier was refused to an extent, my lord, saying that the representation, till the representations are disposed, the oil will not finalize the tender, NIT.
Hmm.
That is what the order passed earlier, my lord.
Hmm.
And if your lordship will find the order that was passed pursuant to the order, that the direction by this honorable court, disposing the representation, they took note of an inspection report of 7/3/2024.
Okay,
That
will
is
will
also-
Mr. Chaudhary reply to his argument?
Yes.
So then we'll wait for some time. Your argument is, this is your argument that it two are different things. First is the earlier order, second is that we have decided to do it our own and we are following this process, and the fact of procuring the materials were disclosed in the affidavit itself.
Yes.
Now just we are executing,
And third-
therefore
third-party
there
rights
is no
have been-
change of situation to pass a fresh interim order.
And my lord,
Others are there, other grounds are
No,
in
my lord,
both
the
party
third-
need not argue.
no, third-party rights have been created, my lord. We have placed orders for procuring my lord, gas compressors. Third-party rights have been created.
So this is only, and after the tender it will be, this is only installation.
Only installation. By the earlier tender, which is not under challenge,
Hmm.
we have placed orders for procuring some materials may have come, my lord, that takes some time.
Okay,
But then for third-party rights have been created.
okay, we'll, after some time,
Lord, will
let
give
me
us
check.
5 minutes.
Huh?
Lord, will give us 5 minutes time.
Okay, we'll give you time because others are waiting.
Yeah.
So instead of repeating, we'll hear him again, Mr. Chaudhary will come and argue. Is not it? So he's competent, we are having no doubt.
And that, my lord, the NIT for procuring the gas compressors have not been challenged. This petition has to be rejected at the motion stage itself.
That will, yes. Wait for some time. Give a copy to Mr. Chaudhary and Mr. Chaudhary, MK Chaudhary,
My lord.
give a copy to
Yes,
him
ma'am.
also.
Yes. At a copy, yes.
Yes. Next case. Matija.
Hi, for bail hearing.
Mr. Das, Mr. NJ Datta's case,
That part hurt me.
that part hard
Yes,
matter.
I am told.
So he is basically pressing on interim. I have expressed my views that we will complete the hearing. If you want to argue today, it's today, or he says on second. It will be on second, we'll complete it and we'll
Yes,
possible in the
Short
court
case, 4 or 5
Okay.
PWs, my lord. It will-
on second. Yes, what is this?
My lord, here in this case, my lord. Well, in this case, Kesdari was called for, I think Kesdari is not received.
Okay. Case diary as called for is not received. List this matter when?
Um, 12 of August.
12th of August.
Oblige me.
For orders item number 7.
Oblige me.
Yes, BTC is there. Okay, wait for some time. Yes, where is Mr.?
Zumdar is appearing.
Huh?
He is
Okay,
there.
after some- Let him come.
I'm sorry, Mallet. In item number 7, may I take place this Mallet?
Okay, item number
7.
7. Learned counsel for the petitioner raised for and is granted, is permitted to take fresh steps upon respondent numbers.
5, 6, 4, 5 and 6.
4, 5 and 6.
Oblige, Your Lordship.
Steps be taken within 5 days and thereafter release this matter after 4 weeks
Oblige, Your Lordship.
with an up-to-date office note. Let this matter be listed, yes.
9,
We'll take it out for some time, sir. Take it, which is on it.
1 for ignition.
I was informed by the respondent that they would seek time to file their affidavit, so I don't know why.
Yes,
they-
for the respondent. Yes, Mr. Bothakur.
No, we didn't file matter.
Now you are operating, you are running the show.
Yes, ma'am.
Okay. Mr. S. Bothakur, Learned Counsel appearing for
For respondent number of BPC, ma'am.
for the respondent BPCL. Press for an adjournment to file affidavit in opposition. Prayer is allowed. List this matter after 6 weeks. In the meantime, full stop. The earlier interim order passed earlier on
First,
11/1/2021. 11/1/2021. Shall continue until further orders. Admission clear, orders matter.
This matter, my lord, I am led by Advocate General, my lord. He is in court number 1 right now, after some time.
Please, Your Lordship, the other side, the learned counsel for respondent.
Huh?
The learned counsel for respondent is in Isle and he has informed us.
Lordship, my senior is Aizal Benz, Lordship. Kindly.
Okay, on the prayer of the learned standing counsel for GST, matter stands adjourned and be listed after 3 weeks. In the meantime, interim order shall continue. In the meantime, interim order parcel shall continue.
Eight pending matter.
Yes, Mr. Mojumdar, we are going for final disposal? Or what, tell us?
Yes, Mayor. I mean, only one thing, Mayor, let him, it will take them some time and I'll try to reply to this. My learned friend possibly did not tell me that it will be taken up for final disposal. I was thinking about the amendment.
Okay,
But it's a very old matter, Lordship me here. I'll.
no, no, we'll not keep it in a piecemeal. Give a date next week.
Mayor, let him start. I think.
No, no, I will not make it. There is some reason.
Minor.
That's why. Not because after this, if we go for other hearings, then you may not be able to come back enough. So you need to, if you want to go through it to next week, you give it. Give a date on
This can be finished, Mr.
Huh?
This can be
No,
finished.
it's easy to say finish. You can finish for in 5 minutes, 10 minutes. The final finishing is done by the court. From spelling mistakes to grammatical mistakes to law.
Everything.
And we are having matters on board, part heard matters of 2013.
I'm sorry, Mayor. My learned friend informed me about the date, but he
Huh.
didn't tell me that.
It was in fact an understanding that we'll decide the
Just
matter.
now, my learned friend is saying that I was talking about.
Okay, Mr. D. Mojumdar, Learned Additional Advocate General, seeks some accommodation to today. Full stop. Prayer is allowed. Please this matter. Sixth of.
Tuesday, Mayor.
9.
Yes. What is your grievance, Mr. Goswami?
May I please?
Just in nutshell, what is
I'll
it?
just briefly indicate what the issue is. This arises out of a NIT, international NIT, for a project financed by Asian Bank. Initiated by an NIT by Power Corporation, Assam
Grid,
Grid Power
Okay.
Corporation. It was an international bidding. Somehow only two bidders
Participated.
submitted tenders, both from India. One petitioner, the other is respondent three. It related to two things. One, the substation at Sonapur and the associated transmission line for the project. That's the thing. The tender terms are, as your lordships know, international tender, very exhaustive. Basically, my lord, there is a novelty which I have seen in the tender documents. So long it was coming from the court. Your actions must be based on reasons. Earlier decisions were there. Ramanna specified it and said that you can't depart from your notified norms. So that was the position. Now, this NIT, Milord, basically, it was a two-bid system. First, you opened the technical bid. Second, those who satisfied that, the price bid. There were only two tenders. So, the novelty which I have seen is that you first open the tender, analyze, evaluate, and then either accept or reject. If you reject, you are supposed to give him the reasons. At this stage, at that stage, and then open the price bid. Then you see the price bid of those who have crossed the technical barrier. And then at the stage of price opening and evaluation, there is a clause that you express your intention by a notice whom you will give the award. There is a format for that. Even at that stage, the format includes the persons who have already been rejected under the technical head. And the grounds are contemplated. So our short submission is that while at the stage of technical opening and in coming to this conclusion of theirs, they did not record any reasons or notify any reasons to us. This is a departure from the notified terms and notified norms, apart from the violation of the Supreme Court judgments and your lordship's judgment, considering a fair, reasonable decision-making process. And secondly, when ultimately the price bid was opened, it was found that the bid of the respondent three, because he was the only bidder now, that is more than that of the petitioner, which we know, because it has.
It is disclosed.
It is already
In the public domain.
We know our offer and his bid is in the website. So there is a difference of 23 crores. Ours is lower. Therefore, a short submission is that in decision making and in evaluating the technical bid, there is a departure from the notified terms, and that has affected us. Secondly, the public interest is involved because you are choosing an offer which is admittedly higher than what this tender placed. And my lord, This process of rejection,
Hmm.
that is also governed under some of the provisions of the tender. What is a responsive tender?
Hmm.
We come to know about our bid only from that notified
Declaration that this is the
declaration
reason
that
you are
intent-
not responsive.
At that stage, of course, the price bid was not opened. It was a notice for price bid in that format. And they said that you are not responsive, therefore you can't participate in the price. Now, if we go back to the first stage of technical opening, there are provisions detailed in the tender itself that contemplates below that if you reject a technical bid on at that stage, you have to notify the reasons. That has not been done. Therefore, there is a violation of that clause, apart from the violation about the process of a fair decision-making process. There also, my lord, how do you come to a conclusion that this offer is not responsive? There is an indication in the tender terms also.
There will be parameters that this will be responsive, this is not.
Yes, how will you determine the responsiveness of a offer? I'll show the clauses. Basically, my lord, there has to be a deviation. Secondly, a reservation on the part of the tenderer about some of the terms. Thirdly, an omission. Then you call that to be a non-responsive offer under the terms. Now, whether in rejecting any of these three tests were applied, that is what your lordship will have to see. Secondly, they have to notify as to the reasons they have found to come to a conclusion that it is non-responsive. In short, my lord, that will be the scope of the argument.
I think we will require those volumes. Not
Which-
necessary.
Which volume?
Additional one, tender.
Not
Yeah,
necessary.
What he has done very rightly, if I may say so, he has not annexed that tender. We have annexed the relevant clauses
Okay,
of the
that is
tender.
important.
That is enough. I
Whole is
think,
not necessary.
Unless he is so something. The only problem is, my learned friend on the last occasion said, in the first occasion, that we have not produced some of the documents. My lord, possibly it will be better for a hearing of this type of case, that an affidavit is filed detailing what they have done, why they are saying it is non-responsive. Otherwise, my lord, he will say something, we will not have the instructions. The hearing will take a little,
Let us have the understanding whether this is a case prima facie satisfaction we have. Then we'll, if we are satisfied on the materials available,
Yeah.
then we'll proceed further. Yes.
as you know.
So
Yes.
therefore,
Yes.
let us proceed.
It is other than a copy of film. Just for your lordship.
Yes, yes. That is better.
My learned friend has prepared a little list of dates. Sometimes we have virtually forgotten about it under the rules because it was what was required to be done.
Yes, yes.
And
But nowadays we insist.
yeah, I think it is better. you
Then
also
we
do.
do not miss anything, even
No,
writing that you
that is
cannot
what-
have a grievance also that I have argued so much, it is not recorded.
Correct.
At least point, I am not saying that it
No,
should
no,
be.
and that is helpful to both the
Both.
lawyer as well as the learned. So. Just brief dates which your lordship. would
Yes.
like to go through. The NIT was issued on 9/1/24, which is at page 24, Milo. Then there was an amendment, which is at page 174. one condition was about the amount which should be in a year 50 crores. That was reduced to 20 crores. That is the amendment, nothing beyond that. Then the tenders were submitted on 28/3/14. And on Milord 6/5/24, the respondent number 2 raised certain bid queries to the petitioner, and I understand to the other person also. That's the normal, Milord, after you open the tender and all that. And we replied to that, which is at page 196.
Yes.
And then, Milord, the impugn order comes. 8/7/24, Milord. Observing that the petitioner's technical bid was non-responsive and the respondent number 3 is responsive, and they notify that the price bid will be open, and the respondent 3 cannot, will be the only person whose bid will be open. That your lordships will find at page 252. Then on the same day, the petitioner made the representation
8/7 itself.
at page 253, saying that please, you have not given any reason. It is why you are saying it is unresponsive, and therefore let us have the reasons. And if you want an independent analysis or evaluation by any authority, you have no problem. But this seems to be a little arbitrary. Then only bid of respondent number 2, that was open on 10/7, because in that notice itself, 8th notice, they are saying that it will be opened on 10th. So it was open, price bid. So this is the short
Facts.
fact. Now, if your lordships kindly have a look at the tender clauses.
Where is that order? 8/7 is page 252.
252. If your lordship just have a look at that. This is called Milord notice of financial tender opening at page 252.
252.
This is to notify that the technical tender evaluation of the submitted tender of the respective tenders is completed, the result of which are as below. Section, that is the petitioner, Milord, non-responsive. The respondent number 3, the other bidder, responsive. In this respect, I also notify the financial tender of the non-responsive tenderer shall not be opened. Financial tender of responsive tender shall be opened through e-tender portal on 10/7/24, within 2 days. At the office of the Managing Director, Guwahati. Authorized representative of the responsive bidder whose financial tender shall be opened may present in the financial tender opening on the scheduled date and time. That's about all. And then, Milord, on the very same day, we submit the representation, which your lordships find at next
Yes.
page
254.
252, 3, and the main representation of the same date is at page 254. That 253 is the covering letter, and this is the representation where we say that let us know why you have treated us to be non-responsive. We refer to our earlier letter pursuant to the query, Milord, which is, the query was on 8/5/24 and our reply was at 13/5/24.
Price bid was open on which date? 10/7.
On 8th, as your lordship has seen, this notice came about non-responsive at page 252. That is on 8/7, and that fixed the matter within 2 days, 10/7. I'm sure there is a clause of a standstill period, no? Of 10 days. They were in a hurry, obviously. So this is our representation. Now I take your lordship to the terms of the case. The tender terms, my lord, starts at page 24 and continues to 173.
It's 24.
Very probably do. But it starts at page 24, my lord. If your lordships kindly turn to clause number 45, you know? Page
45.
45.
Page 45.
So, agar kuch agar karenge. 44, my lord, clause 27, the tender opening starts.
Okay.
This is for the technical bit.
Page, I am at page, clause, you want to say clause?
Clause 27, page 44.
Clause 27, page tendering open.
Page 44, the employer shall open the technical tenders in public at the address and the date so and so. This is how, my lord, the first envelope is open. And then, my lord, it says that it shall open the technical tenders in public at the address and the date and specified in the TS in the presence of the tenders designated representative and anyone who chooses to attend. Any specific electronic opening procedure, if required, is permitted in accordance with so and so. The price tenders will remain unopened and will be held in custody of the employer until the specified time of their opening. If the technical tender and price tender are submitted together in one envelope, the employer rejects the entire tender. Alternatively,
Which clause,
the
Mr. Goswami, you are reading?
One.
27.1.
Okay, okay.
This is the first stage of the opening of the technical bit. Then your lordships kindly turn to page 45. That is crucial.
Clause?
Page 45, 27(6).
Okay, 27(6).
The employer shall prepare a record of the opening of the technical tenders. That shall include as a minimum the name of the tenderer and whether there is a withdrawal, substitution or modification and alternative tenders and the presence or absence of a tender security or a tender security declaration if one was required. The tender's representatives who are present shall be requested to sign the record. The omission of a tender's signature on the record shall not invalidate the contents and effect of the record. A copy of the record shall be distributed to all tenderers who submitted tenders on time and posted online when electronic tendering is permitted. Then 27(7). At the end of the evaluation of the technical tenders, the employer will invite the tenders who have submitted substantially responsive technical tenders and who have been determined has been qualified for award to attend the opening of the price tenders. The date, time, and location of the opening of the price tenders will be advised in writing by the employer. Tenders shall be given reasonable notice of the opening of the price tenders. Then, my lord, 27A. The employer will notify tenderers in writing who have been rejected on the grounds of their technical tenders being substantially non-responsive to the requirements of the tender document and return their price tenders unopened. This is the crucial clause of the tender so far as below rejection of a tender is concerned. And what it requires is a notification of the tenderers who have been rejected on the grounds of their technical tenders being substantially unresponsive. So this is the first requirement of a notice of the reasons. Then, Milord, 27(9), the employer shall conduct the opening of the price tenders of all tenderers who submitted substantial responsive tenders. We are not figuring there because your lordship has seen that 252 notice that we are not required to attend because we are technically unresponsive. Then, my lord, next page 46, my lord.
46.
Yes.
I see. Mr. Goswami, for 5 to 7 minutes.
Clause 29, just to show that, my lord, this whole evaluation process involves, my lord, seeking clarifications also, which they have done through their notice for with queries. So that is clarification of tenders to assist in the examination, evaluation, and comparison of the technical and price tenders and qualification of the tenderers. The employer may at its discretion ask any tenderer for a clarification of its tender. Any clarification submitted by a tender that is not in response to a request by the employer shall not be considered. The employer's request for clarification and the response shall be in writing. No change in the substance of the technical tender or prices or in the price tender shall be sought, offered, or permitted, except to confirm the correctness of the arithmetic errors covered by the employer. So it is their discretion, they can ask, and I'll show that they did issue notice to us, seeking certain queries, and our reply.
You have also recorded in your list of that certain clarification.
6.5 is
6.5.
that, that is not part of the writ petition, but we have, it is part of the tender and process, and we'll give.
You have given the reply is part of this document.
Yes, that is,
So therefore, that is into a reference of.
I'll hand over a note, Milord, the queries and the answers which we have given. That will help your lordship. Then how the tenders, the three concepts, deviation, reservation, and omissions. And then examination of the tender, technical tenders. Then if your lordships kindly turn to page 47.
Yes.
47, next page.
47.
Clause 32, responsive of the technical tender. Responsiveness of the technical tender, 32(1). The employer's determination of a tender's responsiveness is to be based on the contents of the tender itself as defined in IIT 11, which your lordships like to note, page 36 is that we'll get. 32(2), this is important. A substantially responsive technical tender is one that meets the requirements of the tender document without material deviation, reservation, or omission. a material deviation, reservation or omission is one that A, this is the test result, A, if accepted, would affect in any substantial way the scope, quality or performance of the plant and services specified in the contract. 2, limit in any substantial way inconsistent with the tender document the employer's rights or tenderer's obligation under the proposed contract. B, if rectified, would unfairly affect the competitive position of other tenderers presenting substantially responsive tenders. So, Milord, this is the test they have prescribed in the tender document itself. When you will describe a tender to be substantially not responsive.
What is this ITT 11?
Lord,
To tenderers.
instruction to tenderers, which your lordships will get at page 31.
Page 31.
And TDS means tender data sheet, which your lordships will get at page 53. So, Milord, this is very crucial. You can't just often say that this is not responsive. While considering whether the technical bid is responsive or not, the reviewing authority has to keep in mind the 3 tests which are prescribed under this clause. And they are very specific, Milord. One is a deviation. That means you are deviating from the tender terms. Material deviation. Reservation, that means you have some reservations about the terms that they don't want to entertain. Or omission, that you don't do anything or give anything concerning a tender clause. Then a material deviation, reservation or omission is one, then it explains. One, first is, if accepted, it will affect the scope and performance of the plant. That concerns the operational effectiveness of the plant. If you have deviated in such a way that it may affect the plant and machinery, then that comes within non-responsive. 2, limit in any substantial way, inconsistent with the tender document, the employer's rights or tender's obligation. So you have your tender terms with regard to both. If you have done something or given something which impairs the employer's rights or the tenderer's obligations, then it will be unresponsive. Then, if rectified, suppose something is there, but they are rectifying, that has the effect, would unfairly affect the competitive position of the tenderer, presenting substantially responsive offer. So this is a clause concerning the other tenderers who are responsive. So you don't allow something to be given which impairs that. That is the whole idea. So this clause must be kept in mind while judging evaluating the tenders of the tenderers. And if they find merely saying that it is not responsive will not do. They have to apply the test specified in the tender documents and say because of this, this is non-responsive. And that is required to be communicated to the tenderer. Then, my lord, your lordships will have a look at. And 32 if a tender is not substantially responsive to the requirements of the tender document, it shall be rejected by the employer and may not subsequently be made responsive by correction of the material deviation, reservation, or omission. That you can't do. Therefore, while evaluating, you first see whether any of these three things are present. If it is present, they will say that it is unresponsive. Then you can't rectify that. Then below the provided that a 1033(1), that a tender is substantially responsive, the employer may waive any non-conformities in the tender that do not constitute a material deviation, reservation, or omission. So it has to be a matter of substance, basically. Then below 33(2). Provided that a tender is substantially responsive, the employer may request that the tenderer submit the necessary information or documentation within a reasonable period of time to rectify non-material non-conformities.
Yes.
In the tender related to documentation requirements. So it's a flexible process, Bilal. Certain things, if they are present, you are rejected as unresponsive. There may be others where you can amend there that is covered by these provisions, that you can non-conformity, all right, but it can be remedied without affecting anyone. So this is a clause which gives that power to the employer. Then, my lord, 34. The employer will carry out a detailed technical evaluation of the tenders not previously rejected as being substantially non-responsive to determine whether the technical aspects are in compliance with the tender document. This is a second time review. The tender that does not meet minimum acceptable standards of completeness, consistency, and detail, and the specified minimum and or maximum requirements for specified functional guarantees will be treated as non-responsive and hence rejected. To reach such a determination, the employer will examine and compare the technical aspects of the tenderers on the basis of the information supplied by the tenderers, taking into account the following. So this is the process, below, which also requires a further evaluation and where the employer can associate the tenderer and ask for necessary details. Then, my lord, if your lordships kindly turn, this next page is 51. Next, your lordships will kindly turn to page 51.
Yes.
Page 51.
Yes.
Forty-two, no? 42 clause.
42.
Clause 42(1). If standstill provisions apply as specified in the TDS, the standstill period shall be defined in the TDS to specify the duration subject to notification of intention to award the contract before making the actual contract, within which any unsuccessful tenderer can seize the proposed award. So, my lord, this also confers a right of challenge.
What is this standstill provision of TDS?
Provision is at page 60, it is for 10 days.
10 days. Page?
Page 60.
60.
60, my lord. 42(1), ITT 42(1).
Standstill
My lord,
provision is ITT 42.1, isn't it?
Yes, my lord. It is called ITT because instruction.
60, Your Lordship, we've got
Stand, that is
Page
40,
60.
page 60,
60.
42(1). Standstill provisions shall apply. The duration of standstill period will be 10 days. From the date of notification of intention to award the contract. That means, my lord, you have decided that X will be given the work. Then the tender requires that you notify, which your lordships will find at page 151. A notice. At page 151, notification of intention to award the contract. So you notify at that stage before issuing the order.
Now,
is to
will it-
notify you
will it
about-
not mean for the only successful tenderers whose technical bits are clear?
No, it is that subsequent stage of evaluation and
So
opening.
if you see the
Yeah.
notification using the form included in section 19 of the contract forms and include the following information. That information includes, that is to be informed to the tenderer. Now, clause D says the name of the tenderers whose tenders were rejected
Rejected.
and the reason for their rejection.
Rejection.
Your lordship is reading at page 151.
Page 60.
60, yes. There are several clauses.
What do we mean by standstill provision?
Standstill means for 10 days, you are notifying, it will not do
Anything
anything.
defined in the standstill provision
Yes,
in the tender?
yes. Page 16, huh?
Page?
Page 60, Milo.
It says standstill provision. What is standstill provision?
Apply.
It
The
will apply in
duration-
situation. What
duration
do you
of
mean
sta-
by the standstill?
Standstill
Anything defined?
means you status
That
quo.
the grammar meaning. It will
Grammar-
be standstill or anything has been defined in the.
No action will be taken. It's a status quo
It is
period.
like a status quo.
Status quo.
Okay.
cannot
No, no,
tweak.
no, that we understand from the literal meaning. Anything,
Oh, yeah,
whether
yeah.
a standstill is defined in the context of this tender. Any provision?
Let me verify.
Not to my knowledge, subject to what my
Okay,
learned
okay,
friend
that's
will
okay,
say.
that much only.
But
Standstill is
it
understood.
is for 10 days. Your lordship has seen the provision enabling a unsuccessful tenderer to challenge that. So it contemplates that can happen, or you can move a petition before your employer and say that this is where you have gone wrong, do this or do that, or something of that kind. They express the intention by this notice that an award will be given to X, but they don't give it for a period of 10 days. That's the idea. And that is a period, as your lordships have seen, that contemplates even a challenge to that
Yes.
by an unsuccessful tenderer. So everything is within the realm of possibility under these tenders. But kindly see this is at the stage of opening of the tender, my lord. Page 151.
This is 10 days from the notification of intention to award the contract. Where is the what is the prescription for notification of?
If your lordship just turn to that, 151, notification of intention to award the contract.
151?
Yes.
Yes.
My lord has got it.
Notification to intend the award.
So this is after the evaluation, first technical, then price bid, then
Now, in this case, when it was issued?
this is, my lord, this is the impugn order, which is at page 8724, page 252. Page 252. It's a mixture of both.
No, it is not mixture about. It is a notice of financial tender opening.
It is something, a little mixture of both. They are not really going by what they have stipulated in their tender terms. Just see page 252. This is 8724. This is to notify that the technical tender evaluation of the submitted tender of the respective tenders is completed, result of which are as below. Section, that is the petitioner non-responsive. Techno-electric, R3, that is responsive. In this respect, it is also notified that financial tender of non-respective tenderer shall not be open. Financial tender of the responsive tenderer shall be opened through e-tender portal on 10/7/24 at Office of Managing Director, so-and-so, Paltan Bazar. Authorized representative of responsive tenderer whose financial tender shall be opened may be present in financial tender opening on the scheduled date and time. This is something mirrored a mixture. If your lordships look at that clause which I placed earlier, which can mirror page 45, I think. Clause 27(7), if your lordship just again have a look. Because this virtually is a notice for opening of the price bid, page 252. My lord has noted that. And clause 27(7) at page 45, if your lordship see, at the end of the evaluation of technical tenders, the employer will invite the tenderers who have submitted substantially responsive technical orders and who have been determined as being qualified for award to attend the opening of the price tenders. The date, time, and location of the opening of the time will be advised in writing by the employer. Tenders shall be given reasonable notice of the opening. One can relate the page 252 notice to this clause.
Clause 27.
Although they have not followed the way it should have gone, but this is, I think, can be related to.
So therefore, your basic fundamental ground is that you could not have proceeded further without notifying me the reason why it is not responsive, and these reasons is required because you have created a right to challenge those decisions under this provision. This is your case.
Absolutely. Because all this is inbuilt in the tender terms. What is responsive, what is not responsive, you have to apply that test. If you don't give me a reason, how do I meet?
So therefore, according to you, a right of challenge which is created
Under the
itself
Act.
and under the tender document itself is being violated. So therefore, there was an intention. So whether my technical bid is responsive or not responsive is an essential conditions to be informed to me. Otherwise, it violates the sanctity of the entire procedure.
And you will kindly see this. You are issuing this on 8/7/2004 and you are fixing
On 10th.
10th. Why is this hurry? You have two tenderers, don't give an impression that you are going to miss out something. You have a
So
standstill.
according to you, the standstill
The
position
period
will
is 10
start,
days.
standstill position will start from 8th of July.
10 days,
10
your
days, then
notified
so
tender
that we can in
stays.
the meantime do whatever, come to the court or do what is available to redress our grievance.
Right. And on the very date I
Hmm.
got it,
Hmm.
your lordship will see our representation at page 254.
That email.
No,
Immediate.
not, it's a letter. It's
Email annexed with the letter.
yes,
It makes it the first page, second is the letter where you have said that give us the reason. And you have raised this issue that we are entitled for this reason at paragraph 3rd or 4th.
same day.
Yes.
I got it on 8/7.
Hmm.
I represent on 8/7 that what have you done? Why is it unresponsive? I have
For
invested
the,
money
I
to-
think now we can hear him because fundamentally for the purpose of today's hearing, this is the fundamental.
Privacy,
It's yes.
It's consideration.
Yes, Mr. Khat.
May please. You have
any clause give us any right, but other clause also protected the authorities. My lord, my learned friend wants to know the reasons of his rejection. This is the international bidding. My lord.
Hmm.
Each and everything we have to done because it is an aided project. Asian Infrastructure Investment Bank, they funded it. This is the second project in Assam. It's a public interest involved. 440 volt line, the second line. Well, going to be installed in Assam. Now, and there in this tender process, what I find, I cannot directly reject their tender at first go. I shall have to give them opportunity to submit their document shortfall. If they fail, then we can reject it or declare it as a non-responsive. Now they want to know the reason. They relied on clause 27.8. Let us see the clause 28, my lord.
Yes, 28.
Clause 28 at page 46.
Hmm.
May I read it?
Yes.
Information relating to evaluation of tenders and recommendation on contract award shall not be disclosed to the tenderer and other person not officially concerned with such process until publication of contract award. Can I violate this order, this clause? I cannot go by to one clause and take one clause. Am I clear to your
Yes.
lordship? When their right accrued,
Yes.
under this clause is confidential clause. This gives us power to keep it confidential. When we will supply this reasoning, after the my lord intention to award the contract,
Yes.
and we'll supply it when they ask for the reason under 42, 44.2. Am I clear to it?
Yes. Yes.
Therefore, my lord, this my humble submission, this is a premature repetition.
Hmm.
Because if your lordship take the 28, my lord, clause, and that is why I am relying on judgment, my lord, of West Bengal State Electricity Board, case mail. That also international bidding, my lord, to bid system. The adherence to the terms and conditions, the authority as well as party must scrupulously follow the or adhere to the clause of the tender. My line of senior friend argued on 27, my lord, clause 27.8.
Hmm.
The employer, this is the notification, my lord. I can say or submit that there is an intent, our price bidding notice, which has been there here. That's a notice for price bidding. Then even my record is there, my lord.
Hmm.
That's also so that AIB, my lord, what happened? We inform everything to the bank. Bank give us permission that you go for publication of date for opening of tender. And on the basis of permission, my lord, we have given that notice. And that notice cannot, my lord, that notice of, my lord, opening of price bid, my lord, cannot be equated with the intending to.
Yes. Just a minute. Yes.
Well, no. For 42(1), make it clear below. The sanction set shall apply to TDS. The stencil period shall be defined in the TDS to specify the duration subsequent to notification of intention to award the contract. Before making the actual award, Milord. Before
Yes.
actual award, we will issue a notification to intention.
So according to you, the standstill we starts where we have completed the entire process. Now we have decided to award this contract to X and Y on Z. Then we will notify it that we are intending to do this, and 10 days you will not issue the actual award. Award so that others can, this is your case.
Even the form was prescribed.
Yes. And Mr. Goswami's case is that if we go to other clauses, procedure and stages of tender, and we relate to this stencil, it will mean that when our non-responsive regions ought to have been intimated, and there ought to have been a 10 days stencil.
They are relying on for that 27.8. 27.8 only say that to notify the non-responsive is not for the region, Miller. No, only for the, because confidential clause, otherwise we are meaningless. Only to notify that this is the non-responsive, and then that also we don't have done it. My case is very clear. Well, this is the confidential clause is there. We have to follow the abide by the confidential clause, and the stage has not come, my lords. We have not issued the notice under 42.1.
Not yet. Your case is not yet.
It
We
has to
issue
be
it.
decided. That's open it. And that's all. Therefore, my lord, this people, my humble submission, for other, my lord, whether the property is properly rejected or not, grounds will be specified after 42.1. And because we have been protected by clause 28, confidential clause. And therefore, my humble submission is premature and no.
Yes, Mr. Goswami.
Look, the argument virtually nullifies the terms of the tender. Page 46, it says you have to give the reasons. Page 60 says, clause F, you have to give the reasons. Apart from that, my lord, even otherwise, kindly see the position. Substantially, what will happen? You have two tenderers, you have rejected one remains. If we accept that you are not entitled to any reason, therefore I can't go to court. Although I am not
Your case will be price bid is already open.
and if I go after the award is given, court might say, why did you not come earlier? There was a provision for a challenge also. So your lordship have to harmonize this and also keep the public interest in view. That's the ultimate test.
Yes.
Are you, in case of a two tenderers, one is rejected without reasons given, although at different stages reasons are required. Technical bid is rejected, at that stage also reason is contemplated at page 45.
That is your whole case.
Whole case.
Your case is that until and unless I know the ground of rejection of technical bid, now in the meantime, price bid will be open, so I will be out. This is your case.
The impugn order removes me from the scene. Therefore, I am aggrieved that you are not complying with the terms of the tender, which itself says you do a promptly employer if you represent. There's a clause. Therefore, your lordship will have to examine both sides. I know it's an important project for the state. Fix a time limit for their affidavit. We have filed the reply. If they want to file a reply, it should be filed. And then fix the date for hearing. Today itself, I am going to argue it out fully.
List this matter tomorrow for delivery of, the delivery of the on the point of interim. Tomorrow we are
The
delivering.
interim order, they themselves have said that we have not awarded the work.
Yes.
Therefore, if
No,
you
they are-
award
they
the
are-
work and give.
Milord, Milord, this is a time bound project, Milord.
It-
24
it-
So
July.
therefore we'll dictate this order.
It
tomorrow.
will
Milord,
lead to complications. And if a early disposal is, ordered for, then the position gets cleared and both the things are protected.
Just
In the case of a single bidder, there are judgments which say that you have to keep the public interest in view. Apparently 23 crores is higher. But we are a recognized, contractor. I have projects, ongoing projects in 3-4 states, including Nepal also we have. Therefore, it is in the public interest that you have a fair competition.
Because your price is also in the meantime after
Yes,
declaration.
and fair competition is a necessity in a matter of this kind of tenders. It's in the public interest to protect the status quo so that you can, I don't want your lordship to, I am not going to prolong the hearing. You fix the date, we'll argue, give the judgment and let's finish it.
Okay.
Otherwise, they have not given as yet. Therefore, we have come, we are entitled to come because you have not followed the due provisions of the tenders.
Record discussion, Milord.
Huh?
Record.
Because
there-
at this stage, we are not on record. Yes, basically whether there is a violation as Mr. projected by Goswami. If we are satisfied that there is a violation, reasons to be declared, we will consider for interim. If not, then we will reach. That's all.
At this stage, it's a prima facie.
Prima
case,
facie
Milord.
case,
And
balance of
I-
convenience
with
and all.
Great respect, I am saying, Milord, that in the light of the tenders, there is a prima facie case
Yes,
to examine.
yes.
Milord. It's a project of some importance, big project, and public interest is involved because a lower bidder is being.
Only thing is West Bengal is State Electricity Board
No,
case.
West Bengal was.
There is a
different
difference of 40 crores and 80 crores between.
Let us see.
That
case.
is
The
below.
Amount is
Amount
itself not
limited,
an
Milord,
issue.
until and unless valid tender.
That is a consideration in the field of public interest, but certainly the terms of the tender indicate giving of grounds, even after the rejection of the technical
Your
tender.
case in that even if it is otherwise in other tender may not be, according to you, the tender itself prescribe for such a course of action.
Course of-
That is valid. This is your
And-
case, simple case.
And it gives effect to the judgment
Yes.
of your lordship and the Supreme Court. Your lordships know about the judgment. The Supreme Court has in clear terms held in 2 cases that you must give reasons. 90, volume 3, SCC 280,
90 লিখে রাখুন, 2 SCC
1990, volume 3, SCC 280, para 9 and 10 at page 284. And 2001, 8 SCC 491, para 15 and 16 at page 496. Reasons. We have given the one. Because after all, your lordship will have to harmonize the clauses and keep the public interest at as the main focus. In that view of the matter, Milord, the reason even without the terms, Supreme Court was saying
Yes.
that you should give. Here, at least for a change, I have seen at least the contemplate reasons to be given. Not only at the end of it as claimed, but even at the stage of technical bid.
rejection of the.
That's a new thing, Milord. We should really encourage that rather than.
To avoid litigation, they have done all this.
No, Milord, avoiding litigation one cannot.
Okay.
Because there may be very many
Yes,
reasons
yes.
why you
That
come
is their
forward.
intention, whether
Yes.
they can actually achieve or not, that is a
Yes,
different issue.
because they have,
Mm.
that is a good, and they have said that it can be challenged. That normally your
Will
lordship
not-
will not find that tender
Okay, Muslim.
as a lordship.
I'll list this matter tomorrow again for delivery of order on the prayer, on the interim prayer.
Can we finish quickly? Your
Yes.
lordship has understood the whole thing.
My lord, in our
They
matter,
have
My-
now
my
brought in a
only-
new concept.
no,
Yeah.
I've gone through it, my lord.
Mm.
They would like to say that the scope of the present work is different.
Different.
My lord, what I am
They,
on,
what they are saying is to summarize that in terms of the affidavit we have filed, at that point of time, we already indicated that we'll procure this material.
my lord,
Oh.
they are supposed to give it in September, now we're in July. So what I am praying for, my lord, if they want to proceed with the tender, let them proceed. They will not finalize. In the meantime, lordship will hear the matter. After within 2 weeks' time, that solves the problem. Let them proceed, my lord, because according to them, the procurement will be completed by September by their own saying. And my lord, now they say the tender is for the civil work. So it will take some time. And today is the last date of dropping.
You are
Then
not otherwise
There's
participating.
120 days is required for my lord
I
finalizing.
have seen that.
Yes.
It will take some time, no
So
doubt.
therefore, within 2 weeks, lordship will hear the matter, and meantime, they will finalize, they will not finalize. They will proceed. That's my only submission, my lord.
Okay.
Otherwise, the pleadings are over in the earlier case.
Earlier pleadings are over.
So it can be heard any date, my lord. But that protects everybody's right. Supposing tomorrow, my lord, your lordship holds that there is arbitrariness in the decision-making process. Now, in the meantime, if some third-party rights are created, then it will become difficult, my lord. So that's why I'm saying, my
No,
lord.
they are saying at the same time that we have already ordered for some materials in terms of earlier,
Exactly. And
that's
those-
right.
And those supplies will be made by the end of September, by their own statement.
Earlier
Yes.
supplies.
That's what they say. The scope of the work is different because we'll procure materials, the materials which are already there. My lord, I can appreciate if the Oil India would have scrapped my cover work in respect of the 3 units. But in respect of 5, what is their justification? My lord, some engineer sitting in Oil
No,
India.
that's correct.
Yes.
No, that's correct.
Ah.
See,
5
if
they
you,
could have
if
given
you
us.
go by, but that parameters, then that standards, it's difficult to determine.
No, my lord, there is no difficulty. Only thing is if your lordship
And
reaches
more
to-
particularly the earlier, for the purpose, maybe,
That's why I said, my lord.
maybe in a final hearing,
Yes.
there may be, but
So therefore, my lord, the order which I am praying for,
Hmm.
that will not prejudice anybody. They will not be prejudiced. The only thing is, my lord, my interest should be protected in the event I succeed.
okay, this is also tomorrow
That is my.
for orders.
Only, my lord, my submission is, my lord, primarily two. Number one, you have not challenged the earlier tender by which we have created. This is only subsequent and ancillary to that. Number one, and number two, third party rights have already been created. Therefore, I oppose any interim.
Yes.
process.
We'll pass this order because too many methods are there. Instead of starting dictating, we'll dictate in the chamber and openly we'll do it tomorrow. I'll just give the names who are appearing for your petitioner. Mr. Chaudhary is for respondent numbers.
And for the respondents number.
Mr. Kaushik and Mr. Bhatta, you also give. Okay.
Mr. So Das senior advocate leads me
Advocate General was also here after few minutes back.
on the way.
Okay, next, call the next matter. Call the next matter. Mm, Yes, where is now?
He was here, maybe he's outside.
So we'll conclude it today. So he sees there is he's not conceding.
Yes, sir.
So we'll conclude it today.
Yes, sir.
You have given all written arguments. We'll record the your arguments,
Yes, sir.
start dictating at 2. Okay. We'll start dictating at 2. This order. Okay, call. 2 and 3 will start dictating. We'll finish this off today. Mr. Das, we will dictate this order at 2. This item 10 and 11. So item 10 and 11. It's a part hard matter. We have already concluded. Some additions will be made by additional Solicitor General, Assistant Solicitor General, and thereafter we'll come back to your method. But it will take some time dictating. We'll complete it. Will not kept. Inform accordingly. Yes, Borua, you inform the AG. May not be immediately at 2 because we'll complete this meter. Mataji? Our case. Baki keta mata 14, 14, 15, 16, 17. Ki ase? It will take it later on then. Ready? Ready? Okay, fine. Next will come after that method will take up. Call the other. Yes, after.
My lord, we adjourned for 6 because my lord, I've been informed that the petitioner is expired, my lord. I have to confirm and.
What is the issue here?
Issue is my lord, the petitioner has expired, my lord. Issue is regarding my mutation.
Issue is not petitioner is expired. Issue is that you want an adjournment. You know that.
So, my lord, I have to substitute. I have to take the.
Information based on knowledge.
No.
We do not want an FA. What is the issue?
Issue is regarding my lord, a mutation, my lord.
You have lost the file also.
No, my lord, next date, my lord, I have to file petition
No
for
next date.
substitution, my lord.
This case has no next date.
Just last week, they informed me that my lord. Since the my lord, petitioner Laddu Namasudra is expired, so my lord. Petitioner number 1 is expired, my lord.
It is submitted by Mr. S. Nath. Some substantial rights are involved. Submitted by Mr. S. Nath, Learned Counsel for the appeal that the petitioner has in the meantime expired.
Petitioner number 1 is expired.
Petitioner number 1 has in the meantime expired. Accordingly, he prays for an adjournment so that he can do the needful for substitution if necessary. Full stop. Accordingly, prayer is allowed, mattress tense. Prayer is allowed. Accordingly, mattress tense adjourned and be listed in the order column on after 4 weeks. Give a date. 29. Yes. Yes, Mr. Borua.
My lord, here petition is
Borua.
claiming for compensation beyond the right of way. That is our road right of way. This is a contractor duty. But what happened, my lord? Though they are not entitled, similar people were so many people are affected. Thereby, lordship, your lordship may peruse 9/5/2024. I have submitted. Here also, lordship may peruse this. I asked my colleague also because there's lot many people have suffered. That is, they are taking consideration that the committee has been constituted by this one Union Minister Gadkari Sahab and our Chief Minister and this station try to settle the matter. Actually, my humble request for your lordship, he may also file application because otherwise he is not entitled. And he may file application before the concerned authority. Last order, that is why I have submitted, fairly I have submitted. Because they are trying
Which
to
order
resolve the
dated?
issue.
Order dated?
That is 9/5, my lord,
9/5.
2012.
Okay.
They are trying to settle because we want to give something to them, though they are not entitled because affected. They may find.
That committee, my lord, our case is not land acquisition. My lord. That committee is not a party, my lord.
No,
No,
no, okay, fine. He is saying that anyway. So you are not agreeable to this proposition.
We want, my lord, disposal on merit, my lord.
that
Because
in
this-
that case, they are not entitled, my lord. Because we have clearly stated in a paragraph, because that is a beyond right of way. If right of way, beyond right of way, if damage is caused, this contractor is to decide.
Now, what is your case, Mr. Bura?
My lord, here we are claiming the wrongful acts against the wrongful act of the highway authority, where they have damaged our land. The other stand is that, my lord, the committee has been constituted by some other party, where National Highway is not a party to the committee. And that stand is not in affidavit also.
Okay, fine. Now, what is your case on merit?
My lord, the wrongful acts amounts
What
to.
is your claim in the writ petition?
Claim is, my lord, we are entitled to certain amounts for violation of our Article 21 of the rights. Our paddy lands, crops, everything has been damaged. And that damage assessment has also been, report has been furnished before this honorable board
By?
by the revenue authorities.
Okay.
So based on that, my lord, simple case, my lord, since 2017, continuously they have damaged the paddy lands, cultivation is stopped. It's a 6th schedule area and scheduled tribe hills community is there. So we are entitled for violation of our fundamental rights.
Okay,
my
so
lord.
your case is that without there being any land acquisition process or
Yes, yes.
acquiring our land, you have damaged our land during execution of national highways. So therefore pay us compensation.
Yes.
Now revenue authorities admits that this is the actual situation,
Actual
this is. Now what is the stand of the national highway?
National Highway silent, my lord, they are
No,
depending
we have
upon
filed
the,
affidavit, my lord.
kindly see, my lord, the
Silent.
What
one
is the,
order.
no. What, any affidavit filed by the
They
national
have
highway?
not filed any detailed affidavit.
No, no.
But they-
Just
yes,
I am asking,
They have
not asking
filed, they
detail
have filed, my
affidavit.
lord.
They have filed, what is their stand in the?
Their stand is that their engaged contractor has caused the damage beyond the dumping area.
So they also admit that this is damage is caused by
Their-
their contractor. So your argument will be the principal's admission that agent has done,
Yes.
at least admitted liability, they are, that is the.
And in fact,
Now I'll go by affidavit, my lord, because time is also there. Affidavit, we have clearly, short affidavit will become because we have clearly stated, lordship may peruse my affidavit filed on 16/2/2018, signed by one Karge Kamki, project director. Lordship may state to peruse paragraph 5, my affidavit. Lordship got it? This is the crust of the case.
That we understand, but we cannot, that we understand, this is the contractor's liability.
Yes.
You take out the damage from them, pay it to these
No,
people.
because
You
beyond-
cannot say that, you are a state instrumentality. You cannot
Yes,
say that
that's
these are the
correct.
contractors. Whatever you cannot do beyond dumping. Is it not your duty to look into that the citizen's
No,
right
that
is not
why- That
damaged?
is why there is a contract agreement. There is a
That is
contract.
between you.
The-
He
we have
is
contract
not-
agreement.
he is not a
That-
party to this
yes,
contract.
I'm not party.
Which-
He is not a party to this contract.
No, that's correct, my lord, because I have filed affidavit to that effect. They have neither filed reply to this effect also, not required anyhow, not required. But our contractor's liability is there. We have clearly said it is the liability of contractor.
Okay, wait for your turn. But we do not know whether this matter will reach today or not.
My lord, may fix a date, I think.
Fix the date, I mean,
Convenient for lordship. So,
I will see, let us see,
Lordship,
let us see.
again, not.
Because we are dictating a judgment at 2.
Lordship may fix.
Thereafter, some leftover matters will go back to that.
That's a little,
Yeah,
Lord
my
may
lord.
fix our, this.
earlier when this
Next week.
matter. My lord,
Okay,
earlier,
we'll pass this order at 2.
Thank you.
We'll pass this order later on. And what are the other matters? 16 and 17? Anybody? Yes, Mr. Gogoi. What is 16? Can we, if we short matter, you can finish it up, that is, otherwise we'll be, yes.
Land had been acquired by the government for purpose of extension of Gogamukh to Dokokhana for state highway lordship.
Then
They had been acquired our land, they had not been paid.
compensation. What is the stand of the government?
Government stand is the reserve land has been acquired by the
Roadside
PWD
reserve land.
lordship.
Roadside reserve land.
Yes,
Now,
lordship.
how can you decide this?
Lordship, as per our affidavit in reply, lordship,
No, forget about that. If government says this is a roadside land,
lordship.
how can
Actually,
we?
lordship, left side roadside line is 15 meters. But respondent authority have been acquired 22 meters, lordship.
How do you determine that? How do you determine that in read code?
Lordship.
They say 15 meters, you say 22 meters. How do you do that? And what is the remedy?
Lordship.
These disputed facts, tell us. If you give us and we'll pass this order.
I have submitted a representation before the deputy commissioner, lordship.
Okay,
To examine the matter.
we'll dispose of this writ petition to examine this matter. We'll come back and we'll do this. And then what about 17? 17? What is the issue? Give us. Mr. Sharma, what is the 17? Standing Council Revenue. We do not want to keep the lawyers waiting. If we can decide, because
I've been told that Advocate General will appear in this case.
this matter
But
also,
Mr. S, it's a Santanu Bhattakur is,
he's in bereavement.
Lordship.
It is submitted that Mr. S. Bhai, it was S. Bhattakur is in bereavement.
With due respect of your
Lordship,
with due respect of
let
your
the matter reach Lordship because AG is appearing, I do not know Lordship.
Definitely. Yes, Mr. Sharma.
She is a matter of Satra.
This is a matter of Satra.
Satra.
Hasmot Khan.
Hasmat Khan. Satra.
Now, Hasmot Khan's lawyer's father expired. So therefore, we'll adjourn this matter today.
Lordship may keep it for some time if AG comes back, item 2 and 3 he will be here.
We are interested as a disciple of the Satra.
No, that is fine. We will hear you. But Mr. Sharma, problem is that Mr. Bhattakur, we are aware that adjournments are taken that he is his father expired. That's why. Otherwise, this matter of 2023, there are questions of eviction and all.
The same matter has been disposed of by this honorable.
Okay, let us see if none represents the petitioner, then of course we can pass an order.
That is
But if there is an prayer for adjournment, we'll see it.
Maybe fix a date, my lord.
No, Advocate General will address
Much.
this matter. Item number. Yes, where is Gogoi? Give the Gogoi's file. Heard Mr. P.K. Gogoi, Learned Counsel for the petitioner. Also heard Mr. H. Sharma, Learned Counsel for the state respondents. Full stop. The grievance of the petitioner is that petitioner or petitioners?
Petitioners, lord.
Petitioners. The grievance of the petitioners is that their land has been taken over by the PWD, Assam in connection with development of state highway from Gogamukh to Dokuakhana subdivision. But till date, neither any spot verification has been conducted.
Already spot verification has conducted.
Grievance, this was the grievance at that point of time.
Lord.
We'll come to that. However, alleging that no spot verification has been conducted for assessment of amount of compensation, the petitioner had approached this court by filing the present petition. Full stop. The state respondent more particularly the respondents, the deputy commissioner has filed an affidavit through the additional deputy commissioner Lakhimpur, and has taken a stand that has taken that the land acquired land was acquired in the year 2014 and due compensation was paid to the landowners whose land was required. As per the said affidavit, the process of land acquisition was completed by following due process of law, and the petitioners are encroachers of PWD within bracket roadside reserve land. And therefore, the construction and therefore the petitioners shall not be entitled for the construction made by the petitioners over land reserve roadside land, and same is inasmuch as such construction itself is illegal. Therefore, there is no question according to the said respondent. Therefore, there is no liability of the state respondents to pay land acquisition compensation. Full stop. Full stop. It is a further stand in the writ petition that in response to an application submitted by the petitioner number 4 for demarcation of boundary of 1 katha of land covered by periodic patta number 183 and DAG number 263 of Khilamara, a notice was issued for demarcation of land and not for spot verification of assessment of compensation. Assessment of compensation. Where is the stand that it is to 12 meter and 20 meter?
Lordship, I have
Additional reply affidavit.
yes, Lord.
The petitioner has resisted such stand of the respondent by filing an reply affidavit wherein
Paragraph 5, Lordship.
reply affidavit wherein it is the a contention is made that the petitioner have been living in their own Madi Patta land as well as their residential building. It is their further stand that the actual reserved roadside land for PWDs
15 meters, Lordship,
is
left side.
15 meters
Left side.
in the left side and 22 meters in the right hand side. Huh?
Yes, Lordship.
Right hand side. However, the respondent authorities has constructed the land, constructed the road by encroaching the patta land of the petitioner. Full stop. And therefore, they are entitled for compensation. Full stop. In view of the aforesaid disputed questions raised, that is whether actually the petitioners were encroachers and constructed their houses over roadside and were occupying roadside land, or whether their patta land has been acquired can be determined by the revenue authorities by way of an inquiry. And such disputed fact cannot be determined in exercise of power of judicial review by this court. Full stop. At this stage, Mr. Gogoi submits that the petitioner has already raised such grievance before the petitioners had already raised such grievance before the Deputy Commissioner cum Collector, Lakhimpur District, and therefore a direction may be issued to consider such claim of the petitioner and
Circle officer, Lordship.
Huh?
I have submitted a representation before the circle officer.
before the circle officer,
Subonshri Revenue Circle.
and therefore such representations should be directed to be disposed of, and claim of the petitioner should be considered by the Deputy Commissioner cum Collector, Lakhimpur District. Full stop. Such prayer has not been objected by Mr. Sharma, Learned Counsel for the state respondents. Full stop. Accordingly, in view of the determination made herein above, the present writ petition, and as agreed to by the learned counsel for the parties, the present writ petition stands disposed of by directing the respondent district commission, deputy commissioner cum collector, Lakhimpur district, to make an inquiry through the concerned circle officer to ascertain whether any patta land of the petitioner has been acquired in the process, full stop. The petitioner, pass and therefore pass a speaking order in this regard, full stop. While taking such determination, the petitioner be given a reasonable opportunity of hearing. With the aforesaid observation, the aforesaid inquiry, aforesaid process shall be completed within a period of 8 weeks. 8 weeks will be 2 months. Okay, 8 weeks from the date of receipt of a certified copy of this order. With the aforesaid observation and direction, the present writ petition stands disposed of. Parties to bear their own cost.
Highly obliged.
Yes, 10, 11. দীঘলে হবো। Yes. Anything to be added? No. Okay. We can take up these 2 meters together, common judgment. These two repetitions are taken up together. Hard, Mr. Swen, just give your, who is representing whom, just give. The present repetition is filed assailing an order dated 14/12/2009 issued by the respondent number 2, whereby issued by respondent to the respondent number, Joint Secretary AT within bracket and A, DOPT, granting benefit of fixation of merged scales in rupees 7450-11,500 with effect from 1/1/2006 in accordance with CPC space scale of 9,300 to 34,800 and grade pay of rupees 4,600, including fixation at minimum of the pay, that is rupees 7,450 into 1.86 plus 4,600, that is 18,460 to only to the assistants / PA / stenographer C grade for the Central Secretariat Services within bracket CSS, and according to the petitioner, such benefit has not been granted to the field office assistant / steno A in the organizations like BRO to which the petitioner belongs. Full stop. The other challenge is an office memorandum bearing number Swenso dated 25th of September 2016, whereby the pay scale of the assistants and stenographer grade C within bracket PA of Central Secretariat Services were upgraded to a pay scale of upgraded with effect from 15th of September 2016, and according to the petitioner, by way of this notification also, their rights were not considered. Is that it? Their rights were not considered. The yet another challenge is office memorandum dated 13/11/2019. Now, what is your challenge to this 13/11/2019? 9?
After the six CPC, they granted this 4,600 to only the central
Okay.
secretary.
13/11/2009, whereby benefit of great pay of rupees 4,600 was granted to those employees was granted with effect from 1/1/2006 to those employees who were in the who were in the scale of pay of rupees 6,500 dash 10500 in terms of fifth CPC. In terms of fifth CPC.
Basically, they
Thus,
granted-
it is the case of the petitioner that resultantly they were also deprived of from such benefit for the reason that they were not granted the benefit in the fifth CPC, isn't it? No, earlier you were also not in fifth CPC.
I was actually that this particular benefit was granted to the assistants in the central secretary service.
So
With effect from 1/1/2006 in the scale of grade pay of
understand. So
4,600.
since you are, they have demarcated two group. One is civil secretariat and others is you are in the
Field
field.
organization.
So therefore, they were not granted and thus, according to the petitioner, the petitioners were also deprived from such benefit. Isn't it?
Yes.
Yes. The another challenge is an office memorandum dated 16/11/2009, whereby the equivalent employees in whereby the field officer assistant steno A, like the petitioners, were denied the grade pay of rupees 4,600. Isn't it? Grade pay 4,600 in the pay scale of 9300/34800. The petitioner has also challenged an office memorandum dated 14/11/2006. This is also made applicable to
Steno C of the central secretary.
okay, whereby the stenographers in scale D, grade D were granted benefit depriving the petitioners who are similarly situated but posted in the field. Full stop.
This one is not that important.
Not important. 6 we are not going to. Thus, the basic grievance of the petitioner, basic case of the petitioner is discrimination of the equivalent employees working in the central
Secretary service.
who employed in the central secretariat services vis-a-vis the
Field of
the employees who are posted in field duties,
field organization.
field organizations
Yes.
like the petitioners, i.e., like border roads organization, who is basically attached to a field duty. Full stop. Now, now you said what is the Supreme Court judgment says, recent judgment?
Recent judgment says this grant of 4,600 grade pay to the only the central secretary services was basically granting that particular grade pay was not in line with the recommendations of the sixth CPC, wherein a parity in the pay scale of both central secretarial services as well as field services organizations were to be put into parity.
Parity.
This particular departure from this grade pay of 40, because all of them were having that particular scale of 4,500 to 6,500. But this particular OM dated 25/11/2009, just 10 days before the constitution of the sixth CPC,
It was,
there's under departure, wherein only the central secretariat assistants were granted that 6,500 with effect from only 15th of September 2006. That is important, Your Lordship. But this particular later on, this OM dated 13/11/2009, they said that the field office, the central secretariat assistants were getting this scale from 1/1/2006, which is not the case because the
now,
OM
how it is dealt in this judgment, tell us which are the important paragraphs.
Yes, sir. In the Supreme Court, as well as the Delhi High Court judgment, take your lordship to the Delhi High Court judgment first.
Delhi High Court, which judgment?
This particular judgment emanated
Which
from-
was challenged before the
It was-
Supreme Court?
Yes, by the
Yes.
department.
Okay, that is Union of India versus Rajesh Kumar.
No, your lordship, the Delhi High Court judgment is in our rejoinder. I have annexed that particular judgment in the rejoinder, and I'll take your lordship,
Rejoinder.
page number 22.
Rejoinder is at page, or is it okay?
Page number 22, para 15.
This relates to which department?
This relates to under the same ministry, the Director General of Ordnance Factories,
So basically, your central ministry is
the Ministry of Defense.
Ministry of Defense. You are BRO, Border Road Service, you are in the field service. This way is Ordnance Factory, they are also in the field, not in the secretariat service.
Yes.
Okay.
And they are also in the same ministry, Ministry of Defense. And therein, their armed forces headquarters were granted the people who were serving in the armed
Now
forces.
let us see the
headquarters.
Delhi High Court judgments.
Yes, your lordship. If your lordship comes to page number 22, para 15.
Page number 22, para 15.
Yes, your lordship.
Yes.
Now, it is thus evident that the upgradation of pay scales from 5,500 to 6,500 was not consequent to recommendations of the sixth CPC. In fact, this preceded and was prior to the acceptance or recommendations of the sixth CPC. The implementation of the
So this relates to which annexer?
Annexure 2.
In our case, annexer 2.
Annexure 2.
And challenge to, and that challenge number 2.
Yes, challenge.
So this relates to challenge number 2. Yes.
So the implementation of the recommendations was in the form of Central Civil Service Revised Pay Scale Rules 2008.
You want to say the challenge made in this writ petition was also under challenge before Delhi High Court.
Delhi High.
All this.
Yes.
All this.
All this.
So you just show me each of the challenge in this writ petition has been dealt by Delhi High Court in this judgment.
Yes, your lordship. I'll come paragraph by paragraph. Then
So this is challenge to which order? Order dated 15th, it is
this order dated 25/9/2006.
25/9/2006.
Annexure 2, page 44.
So this is 25, just take it option. 25/9/2006 dash Delhi High Court at paragraph 15. Yes.
The implementation of the recommendations was in
Let
the
us not
Yes.
deal with the determination.
Yes.
where it
Then
is.
I'll take your lordship to page number 27.
Page 27. We want the determination.
Yes.
So that we can
Yes.
summarize it. What is the determination?
Yes.
It's will that's why I have kept it dictating clear.
Yes.
I am structured these judgments like this. What was the Delhi High Court's determination against each of these
Yes.
challenge made in this writ petition?
Yes.
Then whether we agree or not agree, that will give our things.
Yes.
Then we'll go to the Supreme Court
Supreme Court.
because whether we agree or not agree, it will ultimately it is a Supreme Court issue. Now then we'll deal with how this Supreme Court dealt with.
Yes.
We'll not write all these
All
facts. what happened to this petitioner, and then then send this matter to them to decide in terms of the determination made by us, made by the Delhi High Court, and made by the Supreme.
Okay.
That's all.
Just
We'll
that-
not fix that you are entitled for this. This
Just-
is not our job.
Yes, Your Lordship, just that in that Delhi High Court, as I've challenged this particular OM, these two OMs had not been challenged therein. Because most probably they were not in, did not have a copy of that, but I had challenged that 13 November 2009 and that 16 November 2009.
Okay, let us deal one
Yes,
by one
One by one.
from 2006.
Yes, Your
For first is 25/9/2006.
Yes.
Which paragraph? 25/9/2006. Challenge number two. Challenge number two. What about challenge number one?
I'll come to that. That
Okay.
was also not challenged in that Delhi High Court.
Okay. So whatever challenge is Delhi High Court letter, challenge number two, 25/9/2006. Delhi High Court paragraph starts at paragraph 15.
Paragraph 15 is
And
one of the
important.
of
And what
the
is the penultimate conclusion? 22.
then 18, paragraph number 18, page 27.
Paragraph number 18. Okay. Yes.
It is evident from the above discussion that a denial of parity is based upon the central government's interpretation of the 6 CPC recommendations. As observed earlier, there is doubt that parity had existed in between assistants working in the OF ordnance factories falling within the jurisdiction of the Ordnance Factory Board and identically situated assistants working in Central Secretariat Services or Central Secretariat Stenographer Service. This parity had also existed as between CSS and assistants on the one hand, and similar ranking employees in all other non-secretariat employees working in different departments in the central government. This parity existed for 10 years, even after the 5th CPC recommendations and its implementation. The singular event which brought about a change was not the result of the 6 CPC recommendations. It was the intervening upgradation of the pay scales that had existed for assistants in all these organizations, pending the acceptance of those recommendations. The upgradation given to all others but denied to
Before that, we'll just briefly note it.
Yes,
Because
Your Lordship.
it's not possible to
It's not
complete
possible.
all the judgments.
Yes, Your Lordship.
Fundamentally discrimination, full stop. Discrimination, full stop. There is no dispute that under the Ministry of Defense, certain persons are under Central Secretariat Services. That is, those are posted in the Defense Secretariat, isn't it?
Secretariat offices.
In the Defense Secretariat office at New Delhi.
New Delhi.
At New Delhi. And the others, like the petitioners, are posted in field services. And such field services includes the Border Road Organization, Defense. What is that this Delhi High Court judgment?
Delhi High Court judgment. DGOF employees,
What is the full meaning?
Director General of Ordnance Factories,
Including Director General of Ordnance
Factories,
Factories and
Employees Association and
no,
other-
not necessary. Employees Association. Full stop. And therefore, they are equally placed and entitled for pay parity with their counterpart who are posted in Central Civil Secretariat. This is your case?
Yes.
Yes. Okay, so you are reading at paragraph 18.
Yes, Your Lordship. Then your Lordship may come to, and I'll take your Lordship the last portion, page number 35. It's at the bottom, paragraph number 24. I'll start from there. They discuss the CATS order. Next page, your Lordship,
Paragraph 24. Okay.
paragraph 24. In the CATS order, several discussions which have been declared that the principle of equal pay for equal work means parity in pay scales only when there is wholesale identity of the work and nature of the post involved have been relied upon. The principle as stated is correct. However, that itself does not explain While almost 4 decades old parity, even 1 decade after the fifth CPC recommendations, which to continue the parity,
Just a minute, just a minute. Okay.
uh, which to continue the parity was sought to be disturbed on the basis of an event entirely outside pay commission recommendations, that is upgradation of scale on 25/9/2006, just prior to the pay commission recommendations implementation. I'll take a pause here. The pay commission was set up on 5/10/2006. Thus 10 days prior to that pay commission setup, they came about with this OM, which is under challenge in point 2.
25/9.
25. The upgradation initially confined only to CSS was given to all others save OF employees and AFHQ employees on the basis of historical parity itself. However, ironically, because that parity in upgradation was omitted to the OF employees, it became a point of departure.
OF's full meaning is
Ordnance factory.
ordnance factory.
Save and accept that point of departure, which is the starting point of discrimination. There is no basis at all for disturbing OF employees who were classified along with non-secretariat employees in the matter of grant of same pay scale. It is not the respondent's case that a 6 CPC consciously went into the subject matter and recommended a break from the past para 3.1.14 and its reference to organizations like AFHQ, Ministry of External Affairs, UPSC, etc., specifically are meant to cover OF employees. In the opinion of the court, the submissions of the respondents to justify the discriminatory implementation of the 6 CPC recommendations are illogical and artificial.
Just a minute.
In the opinion of the court, just after that
Yeah,
UPSC.
yeah, yeah. Okay. Then
Thereafter, in the opinion of the court, the submissions of the respondents to justify the
that
discriminatory
we have read.
implementation of the 6 CPC
Mm.
recommendations are illogical and artificial. They are not based on any nexus with the objective of scientific pay revision, based on the need to have separate pay scales differing from others who form part of the same class. The anxiety of somehow striving to reach to a basis for classification in this case is in effect a hyper or over classification, the like of which was warned against by the Supreme Court in Rupchand Alakha case. Thereafter, Your Lordship, I'll take Your Lordship to paragraph number 26, page number 38.
Just note it down. Delhi High Court in the aforesaid judgment concluded the so far relating to the notification, the impugn notification dated 25/9/2006 concluded the following. The parity between the CSS employees and others existed for 10 years, even after 5th CPC recommendation and its implementation. The singular event which brought about a change was not the result of 6 CPC recommendations. It was the intervening upgradation of pay scale that existed for assistance in all these organizations pending acceptance of those recommendations. Full stop. Then there were 4 decades of old parity. Even 1 decade after the 5th CPC recommendations was sought to be disturbed on the basis on the basis of the communication office memorandum dated 25/9/2006, that is just prior to the pay commission recommendations implementation, within bracket 5/10/2006. Is that it?
No, your lordship, recommendations, the fifth CPC, sixth CPC was set up on 5/10/2006.
Six, that is, the sixth CPC was set up on 5/10/2006.
Just 10 days prior to
So,
setup.
next, save and accept the point of departure, which is the starting point of discrimination, comma, there is no basis at all for disturbing the OF employees who were classified along with non-secretariat employees in the matter of grant of same scale of pay. Full stop. Next. The justification of the respondents as regards such discrimination is that it is for the implementation of 6 CPC recommendation is illogical and artificial. Semicolon, they are not based on any nexus with the objective of specific pay revision based on need to have separate pay scales differentiating from others who form part of the same class. A hyper and over classification is created, which has been warned by the Supreme Court in Urupsan Adalkha versus Delhi Development Authority, 1988, Supplementary 3, SCR 253. Yes, next.
Then your lordship may come to page number 38. That's a concluding portion. Pair number 26. The petitioners were treated historically as equal to CSS employees and enjoyed equal pay and all benefits flowing from equal pay. This was based on
the OF employees were treated historically as equal to CSSS employees and enjoyed equal pay and all benefits following from equal pay. Then
this was based on a previous 4 instances of determination by successive pay commissions that they perform equal work. No other evidence of complete identity of work was necessary in the circumstances of the case. The materials on record do show that the 6 CP stated in more than one place specifically that historical parity in pay scales ought not to be disturbed. Such being the case, this court is of the opinion that CAT fell into error in holding that the differentiation was facially justified and could not be gone into given the nature of restricted judicial review. Consequently, a direction is issued to the respondents to fix the members of the petitioner association and other similarly placed assistants working in ordnance factories and the OFB in the same pay scale as was given to assistants similarly placed in CSS, Army Headquarters, etc., with effect from the same date.
done, paragraph 20.
As was.
Okay. Now, how Supreme Court dealt with this?
Yes, your lordship.
Such decision of Delhi High Court was taken to challenge in the Supreme Court
By the Union of India.
by the Union of India, and the Union of India, while upholding such determination made by the Delhi High Court, concluded the following. What is the salient feature of Delhi High Court judgment?
Basically, the Supreme Court concluded
Yes.
that at page number,
That is Monupatra judgment,
yes, your lordship.
paragraph 3.
Paragraph 3, of course, it states out the basic.
Okay, which are the conclusions? We
yes,
have to
some-
summarize the conclusions.
Yes, your lordship.
That will shorten our job.
Yes, paragraph number 13, last page, your lordship.
Paragraph number
13.
1-3. Come on.
Further, what was also taken into consideration by the High Court is the historical similarity in pay scales, which existed prior to the recommendations in the 6 CPC. Such historical similarity, which had existed, had taken note on, and in that light, the pay scale which was applicable was taken into consideration and had accordingly arrived at a conclusion that the employees in the headquarters of the ordnance factories being similarly placed cannot be discriminated Therefore, such consideration in the instant circumstance, the High Court has adverted to the situation and has never rectified the fact pay anomaly. In fact, the question of parity with regard to pay scale to the assistants in the lower formations in the Indian Navy with that of the assistants in CSS was held as discriminatory and in violation of Article 14 in the case of All India Naval Class Association versus Union of India and others arising out of special petition number 29204 of 2019 dated 27/7/2022. As noted by the High Court, it is evident that parity of pay scale vis-a-vis LDCs, UDCs, assistants, PAs, and stenographers was maintained even prior to 1/1/1986 under the third CPC recommendations. This parity was continued in the fourth CPC recommendation and the fifth.
Uphold dismissing the appeal of the Union of India, primarily on the ground that the determination made by the High Court as regards historical parity between the employees posted as secretariat services and outside secretariat services, and accordingly and thus the High Court has not entered into the classification or comparative equality between the between the employees under Central Secretariat Service and field service and held that what Delhi High Court did is that it upheld the historical parity, and on the basis of historical parity, such order can be passed. Full stop. The Learned Counsel for the petitioner submits that the present petitioners are also discriminated on the basis of order office memorandum dated 25/9/2006 and 6, in as much as they are also discriminated against their counterpart in Central Secretariat Services, in as much as they are posted at field duties, field organizations like Ordnance Factory and BRO. Full stop. Therefore, the aforesaid judgment squarely covers the case of the petitioner, and accordingly, he prays that this matter may be remitted to the learned, relegated to the employer so as to fix the scale of pay as determined by the Delhi High Court in so and so and affirmed by the Honorable Apex Court in so and so.
Also, I'd like to rely on one particular paragraph of the 6th CPC, which
Okay.
relates to this particular departure.
Okay.
Page
Count,
number 47.
Page number
47 of the writ petition.
furthering proceeding further, the Learned Counsel for the petitioner referring to annexure
Annexure 3C, 3, page 47.
referring to annexure 3 P3 P3
Page 47.
Uh.
Para 3.1.4.
referring to the referring to which is
Recommendation of the 6th CPC.
which is the chapter 3.1 of the recommendation of the 6th CPC contains that the sixth recommendation also accepts the historical parity between the petitioner, between the employees under secretariat offices and field offices.
At para number 3.1.4.
Yes, I have this. The aforesaid paragraph is quoted here in below. Okay. 3.1.4, page 47. Green mark, green pencil mark. Okay.
And the ultimate recommendations
Uh-huh.
is at page number 51, para 3.1.14.
Ultimately, after discussion, the six CPC made its recommendation at paragraph 3.1.4
3.1.14.
to 3.1.14, which is also quoted here in below. Page 51, pencil mark to pencil mark.
And with specifically with regards to borderers organization, at page number 53, para 7.3.
The CPC made the following recommendations as regards the Borgard Rose organization at paragraph 7.39.5, which is also quoted here in below.
And 3.6, 39.6.
39.6. Page 53, green.
And most importantly, next page, Your Lordship, paragraph number 7.3.
7.3.29.
39.24. Parity with secretary.
So far relating to the parity with
Secretary.
secretariat, the recommendation is discernible at at paragraph 7.39.23. The relevant portion is quoted here in below.
2.4, Your Lordship.
2.3.
2.4, Your Lordship. Parity with secretary.
Relevant portion of paragraph 7.39.23 and 7.39.24 are quoted here in below. So 7.39 green mark, only green mark, and 7.3924 whole. I have already marked all this.
So after this 6 CPC came out, thereafter on 13th of November, which I have challenged, which was not under challenge before the Delhi High Court, at page number 61, page number annexure P7, they came out with this OM after the 6 CPC came out, saying that the assistants in Central Secretariat Services, since they were drawing the pay scale of 6,500 to 10,500 as on 1/1/2006, therefore they will be granted 4,600 grade pay. That was the basis why they were granted 4,600. Now, if we go to page number 44, annexure P2, wherein that upgradation, the departure was happened with regards to only assistance in the Central Secretary Services, that OM specifically says that this OM is in effect from 15th of September 2006, not 1/1/2006. As on 1/1/2006, they were drawing that pay scale of 5,500.
Now this is order dated. This relates to order dated. This argument will be regarding order dated
13 November 2009.
13 November 2009.
Annexure P7.
Just a minute. (13/7). Just a minute. 13/7.
13/11/2009.
Just a minute. 13/11.
2009.
Okay.
Annexure P7, page 61. And more particularly, paragraph number 3 of that OM. Consequent upon the notification, page number 62, I'm reading from page number 62, paragraph number 3. Consequent upon the notification of CCA's revised pay rules 2008, Department of Expenditure received a large number of references from administrative ministries, departments proposing upgradation of the posts, which were in the pre-revised scale of 6,500 to 10,500 as on 1/1/2006, by which were in the pre-revised scale of 6,500 by granting them grade pay of 4,600 in the pay band 2.
What is your ground of challenge to this? Why do you challenge this?
Because this
Just one liner.
they are wrong, Your Lordship.
Why wrong?
Because there, the assistance,
Hmm.
as per that 25th September 2006,
Hmm.
the assistance were granted this 6,500 only with effect from 15th of September 2006, not 1/1/2006.
Okay.
Only those who were having that particular pay scale of 6,500 as on 1/1/2006,
Hmm.
they would be granted 4,600. Not those who were granted that scale of 6,500 as on 15th of September, they will not be granted, Your Lordship.
Hmm.
That was the departure.
Just let us fix. So, 13/11/2009 provided that those who were in the scale of pay of 6,500 to 10,500 as on 1/1/2006,
Yes,
they were granted
great pay.
grade pay of 4,600 with effect from 1/1/2006.
Wait from 1/1/2006.
1/1/2006. So therefore, 1/1/2006. And in 6 CPC, grade pay was determined at what stage?
At 4,200, everybody,
Everybody.
both secretariat as well as field organization. That was the parity which was obtained, which was
Okay,
to
okay.
be achieved.
Therefore, you say that so this was a what do you call it? Switchover of fixation for those who were at 6,500 under fifth scale on 1/1/2000.
Yes, yes,
This is your case.
yes.
So therefore, it cannot be applied
To the field, to the central secretary
central secretary.
assistance. This was the departure, and whatever the fifth 6 CPC wanted to achieve,
Suppose
bringing,
it is given to them. What is your difficulty? You are not given.
Lordship, that is what I'm bringing
ah.
parity in pay scale
Hmm.
based on the 6 CPC recommendation. The 6
So
CPC.
if we go by the Delhi, suppose we agree with Delhi High Court judgment, then these will be not relevant.
Lordship, yes. Otherwise, that will not be relevant.
These are not will be
If
relevant
the Delhi High Court,
because that is the foundation.
yes, yes.
Now, whether Delhi High Court's case is totally applicable to you
Yes.
or not
Yes.
is to be delivered.
Yes.
Once it is delivered, other determination will be irrelevant.
Yes.
Is that it?
This is in addition to the Delhi High Court. and
Delhi High
Supreme
Court
Court
judgment, these are addition which were not before challenged, but fundamental is that
Delhi.
you are equally stated or not.
Yes.
If we hold that you are equally situated or there is a historical parity,
Yes.
then rest will be followed, and who is in 4,000, who is in 6,000,
Yes.
it should be determined by them, not by
Yes.
this court.
Yes.
Is not it?
Yes.
And if we say that no, you don't have any parity, we will not go further, simply will dismiss this writ petition. That's all.
Yes.
Per contra, Mr. Dev Chaudhary, learned AJ,
Yes.
DSG, submits that there is no historical parity in as much as such determination of parity is required. Determination of parity between two sets of employees are required to be done by an expert committee, expert authority like pay commission, and it may not be a job of a writ court exercising its power of judicial review. According to him, the pay structure has been evolved keeping in mind several factors like method of recruitment, level at which recruitment is made, the hierarchy of services in given cadre, minimum educational/technical qualifications required, avenues of promotion, the nature and duties and responsibilities, etc. etc. Full stop. Full stop. Therefore, not full stop. Therefore, even though the nomenclature of post held by petitioners and those Central Secretariat Services, CCS, and Central Secretariat Stenographer Services within bracket CSSS may be the same, or even the nature of duties and responsibilities be same or similar, but the method of recruitment being different, the state may maintain different identities of these two cadres, as there could be inter-se distinction between them. And therefore, the action of the respondents cannot be may not be interfered in exercise of this court's power of judicial review. Full stop. Mr. Chaudhary, learned counsel, in support of such contention, relies on decision of the Honorable Apex Court reported in 1993 Supplementary 1 SCC 153. That's all. This is your case.
Basically,
This is your case. He further contends that the determination made by the Delhi High Court and affirmed by Supreme Court is in a different context, and in the backdrop that such determination in the backdrop of a determination made by Central Administrative Tribunal, which is not the case in the present petitions, and therefore such judgment shall have no application in the present case. Full stop. Hearing concluded, judgment reserved. We'll add other things. You have written given anything? Which paragraph?
Lordship, in page 3, I have relied upon another case.
Okay.
Uh,
Mr.
2007 8 SCC 279. And
উপরে দিব,
2011
উপরে দিব। Mr. Chaudhary further contends that the grant of pay scale or determination of the same is purely an executive function, and Reed Court should not interfere with the same. And in support of such contention, he relies on the decision of the Honorable Apex Court recorded in 2007 8 SCC 279.
And there is another one at
Full stop.
below.
He further contends that grant of parity in pay scales depend upon the comparative evaluation of that we have already given. Just you write it. Also relies on the decision of the Honorable Apex Court in 2011 11 SCC 122.
Your Lordship, per
Yeah.
contra,
Yes.
this particular argument, I just want to reiterate.
Countering such argument, Mr. Bora, learned counsel for the petitioner, submits that
It is the basically the 6 CPC, which is a specified specialized body set up by the government.
contends that in the case in hand, the sixth pay commission itself has held the petitioners and the CSS, their counterpart in CSS to be to having parity, and in the similar circumstances, the Delhi High Court has already held that there has been a historical parities for decades till the order dated 25/9/2006 was issued, and such order was issued only 10 days prior to the constitution of 6 CPC.
And more specifically, para number 3.1.4 of the 6 CPC and 7.3.9.14.
Okay.
24.
Hearing concluded, judgments reserved.
Oh,
Yes, what about that leftover admission matter, Advocate General? Will it be done or what? Where is Mr. Das? Yes, then call next case. Yes. Yes, Khalid, where is your senior? Yeah.
Lordship, he is on Lexington court number 17. Lordship,
Now, then what to do?
Lordship, perhaps that matter will be taken up at 4:15. Your Lordship, he'll be coming shortly. Your Lordship.
Do you expect this matter to be completed starting at 4:15 by 4:45? Will not do it half-hearted. Okay, well, let us wait till 4:15. Let us see. Yes, next case. 11 to 12, 13. Ah,
Part of matter lordship.
yes.
My lord, in this case, my lord, I have prepared, my lord, a written argument. And basically, my lord, we are relying on,
Written arguments of how much pages?
because I
How
have
many?
put it all
How many
evidence
pages? Huh?
for your convenience, my lord.
Ah.
Reproduce the entire evidence of PW 6, 35 and 37.
No, your written argument contains how many pages?
Lord, it is of a little bit, my lord, voluminous, 67, my lord, 70 pages.
70 pages written argument.
Yes, because I have given all decision and how decisions are applicable. Everything, my lord. Because as many as, my lord,
You could have typed the evidences also. That
My
would
lord.
have helped us.
I will not refer to all evidence.
You have
Lord,
to all type all evidence.
All evidence, I'm not going to refer to all evidence.
Ah.
Only respond PW 6, 35 and 37. Because, my lord, only question is, my lord, whether I am involved in the process of opening the bank account. I being the manager of the bank. My lord. And the official bank official were examined. On the other hand, my lord, there are two other accused person. They were
So
ultimately
give
made.
us a written copy of the written argument.
My lord, is already on record.
Already on record.
Yes.
Spiral binding.
Huh?
Spiral binding.
Written argument spiral binding.
There are two, my lord, compilation. One is judgment, another is written argument.
Okay, then your job is done.
Yes, my lord.
Your job is done. We will now hear the amicus.
As a lordship, please, my lord.
Yes.
And my lordship kindly take into consideration, my lord, one more fact, my lord.
Ah.
The appellant is now at the age of, my lord, now at the age more than 93, 94 years.
Hmm.
And, my lord, at one point of time, my lord, question arose whether he is still alive or not.
Do you propose that we should adjourn it for
No.
some time
No.
so that
No. No, I'm not saying that. my lord.
Seeking leniency.
Huh?
He's seeking
Leniency. At this stage, my lord,
Why leniency? Seek for acquittal.
96, my lord, he will create another problem for the jail authority.
So you are not confident enough that it's a good case.
No, obviously, my lord, because huge numbers of witnesses were examined, huge number of exhibits were
We
examined.
need the pinpointed. What are the evidence?
Yes, I have given in my written
That's
argument.
all.
If your lordship will take some pain, my lord, at least to go into at a glance of my written argument.
No, I'll not at a glance. I'll go detail.
I know, my lord, lordship, my lord, you have a great patience, my lord. I know it personally. Therefore, my
People
lord,
like you have taught us the patience.
my lordship kindly go through my written
This
argument.
case itself is a patience. How many days we have adjourned without imposing cost? That we have learned from you. That
I'm-
you must be patient.
I am grateful to your lordship.
Yes, amicus.
So I had also submitted a short written argument. Your Lordship, the principal issue is that
Only how many witnesses are there?
46, everybody is not required, Your Lordship.
But everybody is not required for you. But for the judge who is sitting here, he is required to record who has stated what. Isn't it? Or can we say that everybody said these evidence are not relevant, should not be considered, then we'll record and we'll not go to that evidence, only vital evidence. If you say, Mr. Purkashta says, and he says, a public prosecutor, that these are the vital evidence, others discussion is not necessary.
No, in this case, all evidence are, all witnesses of all evidence are. There is a degree of importance still, there is a, I am, as an amicus, I'll
Okay.
be neutral, Your Lordship. There's a degree
Yes.
of importance. Some of them are perhaps, their testimony is more important than the others.
Yes.
Yes, Lordship.
According to you, who are the star witnesses?
Yes.
PW6 is very important.
The PW6.
Star witness is PW, just these are the preliminary.
Yes, PW6.
Mr. Das. What will happen to your case?
In one of the case, both two cases.
We understand this is a public project. He is having urgency. Isn't it?
Lordship, this one.
No.
Biotech.
Biotech.
Yes, Lordship.
Yes, urgency is a public project.
We studied in both PR in other case also. Whichever case we studied, those cases, today we prepared 3 cases, all 3 cases adjourned, and this case we did not prepare. Because if those cases started, it would have consumed 2 days.
Okay, because otherwise also see today's we are trying to this all pending matters,
Yes.
at least 2 we have
7,
finished.
8 and 9 I have difficulties. There are
Both you agree,
7, 8, 9 after.
Let it be.
There are 2 matters. Another matter, they say that Advocate General will appear.
6, would it be on 6th of August, Lordship?
This is item number
Item number 2 and 3.
2 and 3. As agreed to by the learned counsel for the parties, list this matter on
6th of August.
6th of August 2024.
Interim
Interim order pass earlier, shall continue till then.
Deeply obliged.
Okay, and what is the other matter? 7.
17.
17.
They are all same parties, on same.
17 also.
Yes.
There is Mr. Bothakur is there. That's why we thought that.
Thakur, yes, was there in this case. He's still there.
Okay, you are for a petitioner.
I am
You are
for the
here.
petition.
Okay, fine. Mr. Sharma was here. He expressed some urgency.
I think yes, he will be with me.
I am the disciple of the Shatra.
Yes. So he will be watching the proceedings.
Proceedings.
He will be a fence sitter.
We'll miss his argument. That's
This case,
We
item
will
number.
argue some.
Pusha.
All from Borpetal.
all.
All
This case, the same cause of action, the Honorable Justice Mary disposed of.
Those are on merit. We'll argue on those.
Okay, since time will not permit, so we'll fix it on 7th.
No, 7th it will be difficult.
No, what is 6th? 6th. Same order we to do.
Highly obliged.
We'll miss your argument, we know that.
There is an interim order in this.
Yes, but same order. It will separately pass. Okay.
Highly obliged.
So let us now hear Mr. Pukasta. He is
The patience and pain both are given to this honor. Whether we will start we can throw lights.
now the written argument is of 70 pages.
70 and the petitions, normally it crosses 100 paragraphs. And when we write the
Now sometimes I get surprised. What is the pages are relatable to what? Length, breadth. Yes, Mr. Pukasta.
we wish all pain and patience.
That's why we thought that you all should be relieved from this.
It is the talk of the day, my lord. Everyone used to say this type of comment is to make my lord against me, my lord. And the habit I have developed.
Today's comment, this comment I am hearing from Niloy Datta
Yes.
about last 25 years.
And this is the habit I have
comment.
developed, my lord. What can I do? I cannot abandon this habit.
We have, I do not know, this may be record or, but we have heard that some synopses were
No,
also around 55 pages.
no. It's a good joke. Nothing more, nothing like it.
Yes,
Can I prepare a synopsis of 57 pages?
yes.
Everybody will remember me when I will be nowhere.
No. Yes.
Lordship, the important witnesses are.
These are just preliminary.
Yes.
See, let me be frank. We'll not be able to finish this today. More particularly, we'll have to, in the meantime, when hearing goes on, we'll have to start dictating the evidences. How many witnesses?
46.
46 witnesses. So 46 witnesses, we'll have to record everything. Who have said what is the cross examination. We'll take out the cream later on. But today we are as a preliminary, what are the issues, who are the star witnesses, let us understand that.
Lordship.
In the meantime, this will also help us. Yes.
PW6 is very voluminous.
Hmm?
PW6 is very voluminous. Evidence of PW6.
PW
If your lordships go through the evidence of PW6, it will take 1 day.
Hmm.
Very voluminous.
Yes,
PW6, PW12,
PW6,
PW12,
Hmm.
PW14,
PW14,
PW16,
PW16,
PW27,
PW27,
PW29,
PW29,
PW35,
PW35.
PW37. This is the handwriting expert.
Okay.
PW40, a handwriting expert again, same expert was examined as two different witnesses.
Hmm.
PW38, PW39,
Hmm.
and PW45, who is the IO.
39 and 45.
45. Allegation in a gist is that there was a company called Messrs. Assam Farmer Friends Private Limited. It had a branch at the SBI headquarters. So it had a current account which was under default. In the meantime, at the SBI Agricultural Development Branch, which is called ADB branch at Howli, 11 people opened accounts. So, Lordship, there is a banking procedure called invoice purchasing. What happens is, or it is
Invoice?
invoice purchasing. It is called bills purchase.
Oh.
It is known by many different terms, but in effect, what it is that today I sell something to a company or somebody, and I raise an invoice which is payable after 1 month. But I need funds now. So I will take that invoice to the bank. So if I have to receive 100 rupees, the bank will give me 95 rupees now. And later on, the bank will encash their invoice and get the entire 100 rupees. That 5 rupees is the bank's profit. And because I get the funds now instead of having to wait for a month. So that's
kind of an interest.
Yes. So in this, what happened? These 11 people, the allegation in the FIR, these 11 people, they
How many accused are here?
three accused, Your Lordship.
Total accused initially?
Initially, they were charged only 3, Your Lordship.
No, FIR 11.
FIR named 11.
Named 11, FIR 11 accused. Then charge sheet.
Charge sheet against 3 of them.
Charge sheet 3.
3.
And trial against 3. Trial 3. Then conviction 3. Now, bank officer is represented by Kurkashta. And who are the others?
Other 2 persons are their established identity is that they are the directors of that firm called Assam Farmer Friends, which had a current account in Guwahati.
Okay.
So what happened? The 11 people who had opened a bank account in Howli, they represented before the bank that they had sold some goods, Your Lordship, to a firm called Messrs. Inputs Corporation of India. So they were supposed to receive money from that firm. So those invoices were submitted to the Howli branch who purchased them on the understanding that when the amounts become due from Inputs Corporation, the bank will receive the money. What has happened, the case projected by the prosecution is that the amount that these 11 accounts went into these 11 accounts, some amount was diverted into the account of Assam Farmer Friends to regularize their account because that account was in default. Some account was again sent back to Inputs Corporation. With that amount, that money, Inputs Corporation repaid some of their amount against those invoices. So bank's own money is used to repay the amount due to the bank.
It's like Hawala.
So that process kept on continuing. So there were some minor defaults. Finally, the defaults became so large that FIRs were registered. CBI was entrusted with the investigation. So in those, after the registration of the FIR, charges were after completion of the investigation. Charges were framed under sections 120B, 420.
In the charge sheet or charges frame?
In the charge sheet.
Okay.
In the The charges were framed, charges were framed.
Charges, okay.
Charges were framed.
Charges frame.
Under sections 120B IPC,
Hmm.
420 IPC, 467, 468, and 465, 471. And in respect of the appellant represented by Mr. Prukayastha, additional charges under sections 13(1) and 13(2) of the PC Act, Your Lordship,
You see, against the bank manager.
against the bank manager. So the principal,
Pension, you are getting pension?
I was the departmental proceeding and I got the exoneration in the department.
Okay.
So there is no any.
Okay.
so what the prosecution is seeking to prove is that 11 accounts that were open,
Open.
those documents were forged.
Hmm.
Because all the principal offense, Your Lordship, is the offense of forgery. So the charges are 467, 468, 465, and 471.
Hmm.
In fact, 468 is forgery for the purpose of cheating. So there is a corresponding charge of 420 also.
Hmm.
And then there is a charge of criminal conspiracy and conspiracy under 120B. So perhaps if the charge of forgery is established or otherwise,
Other
then
thing-
others will
follow.
follow, Your Lordship. So, Your Lordship, to establish, I'm just giving a gist, Your Lordship.
Gist,
that-
this
yes,
is the gist, okay.
To establish the charge of forgery
Hmm.
or the connected charges, which is the third, fourth, and the fifth charge, the prosecution relied, the principal witness for the prosecution, the evidence of the prosecution is the testimony of the handwriting expert and the samples drawn and the report of the handwriting expert. These are the principal, this is the primary evidence on the basis of which the charge of forgery has been sought to be established. There is one difficulty, Your Lordship, that initially there were two investigating officers in the case. So handwriting samples were collected by both the officers, but only one of them was examined here. Secondly, though there were independent witnesses who were present when the samples were collected, not all of them were examined. And even those who were examined, Your Lordship, even they did not, in their evidence, they did not say when, nothing about that collection of
They
the
did not support the prosecution's.
they didn't, they were silent on it. No question was put to them either in their chief or so consequently nothing was there in the cross as well.
Who are those witnesses?
The witnesses, I'll give the names of the 4 witnesses across all the
Okay.
documents. In fact, Your Lordship, one person whose handwriting sample was collected, one person called Bhuvaneshwar Goswami, he was not made an accused. He was examined as prosecution witness number 35. He was not made an accused.
Okay.
So in fact, even in his testimony,
Hmm.
he did not say anything about this collection of his handwriting sample.
Hmm.
Now, no, he was not made an accused. He was not made an accused. He was only examined as a witness, though his handwriting sample was collected. But in his testimony, he has remained silent about that whole procedure of how it was collected, when it was collected.
Now, who are the witnesses
Yes.
regarding collections of
Yes.
468?
There are
Except beyond.
four people whose names appear
Hmm.
across all the samples, different 2 witnesses in each document, but effectively 4 people who are SB Das, one person called SB Das,
Hmm.
one person called SS Bhattacharjee. They were never examined.
Hmm.
Then there was PK Thakuria, who is PW6.
Okay. TW6.
PW6.
Hmm.
Even in his testimony, it's almost 100 pages. Huh? It's almost 100 pages long. He has remained silent about this aspect.
Okay.
70 pages, isn't it? 70 pages. He has remained silent on this aspect. And there was another person whose initials were there in the sample forms. His name in that sample form was given as G. Sharma and his signature was there. I found a witness called Golab Sharma. Maybe it is the same person. Why I am saying maybe, Your Lordship, because even in his evidence,
He has not
he has not said.
What
anything.
is his number?
He's PW 29.
PW 29.
29.
Okay. Yes.
So, if the, because
So you want to say that the sample, it's is of so and so is itself is not proof.
That is because otherwise the admitted signatures are there,
Hmm.
where my signature are admitted in my forms.
Hmm.
That sample is correct. He has said that the person whose handwriting is this in
Hmm.
admitted signature matches with this in the sample, but whose signature it is in the sample, that has perhaps not been conclusively proved
Okay.
or beyond reasonable doubt.
Hmm.
And if the opinion
So
of the
comparison admitted signature on the basis of which the opinion was given by the forensic is the signature on the basis of those samples or it on the basis of some admitted signature in some documents.
it is, I think, because those, while I am facing a difficulty, the report of the handwriting expert says the admitted signature marked in red. Now, because everything that was provided to me in black and white, I do not know which is that portion, but it appears that there is some, perhaps my learned friend will be able to enlighten your lordship on that.
You can see, go through the record
Yes,
also.
because it refers to a color,
Mm.
but because everything is in black and white, so I presume that it is in those it must be in marked in red in the.
So what was compared? The sample taken or some documents which is admitted to be
The sample taken
Mm.
with some documents which are admitted to be our signatures or the signatures of the accused person.
So sample is if not collected properly or if there is a doubt that whether this is the sample of the same person,
Yes.
then what will happen? This will be another issue.
Because what
Okay.
has to be established is are the persons who have forged the documents to open those 11
Okay,
accounts.
so therefore there must be a proof of signature in the forged documents
Yes.
and the admitted sample. That is why I'm asking.
Yes, yes. So what
Admitted, which one is the admitted
so
signature?
what they have compared, your lordship, is my suppose the sample of the accused person number 2 and 3,
Mm.
accused some samples of the 11
Whether,
fictitious persons.
whether the samples are compared with the forged one.
With it is
Question
compared
document.
it is
It is a
compared with the
question
forged
document.
document.
Huh?
Signature appearing in a document, those are question document.
Question document.
Question document, those question document were compared with the sample.
Sample.
admitted. That is the procedure.
That is what I'm saying. So if it is compared with the sample, now if there is a doubt created or challenge made during the cross-examination that this is sample was not properly collected or this is not the sample of this, then question of the admission of the sample will come.
Yes.
Because
Correct.
it must be an admitted signature.
Correct.
If that challenge is made during cross-examination,
No such challenge.
that will have to go through.
Challenge was not made, your lordship. Because in
Any suggestion?
because what
Any
happened,
suggestion that these are
no evidence was laid, your lordship, to prove
Achha, no evidence was
in
laid
chief-
to show that this
yes,
was the
in-
so collection of sample itself was not proved. So there is no question
there
of
is no question
challenging it.
of challenging.
Okay.
Because no evidence was laid to prove
Okay.
that collection of samples
Uh,
apart from
or that this is the sample of so and so. It
Yes,
was
yes.
collected by so and so and it was done is mess. I was witness to this.
Yes,
This
that-
was not even
this
there.
is not there. That is precisely
Okay.
what is lacking. Because otherwise, the chain is, if we read it as a story, the story sounds to be plausible, but it has to be examined against the
Story. So basically, these are circumstantial evidences
Yes,
are
yes.
also there. Basically, circumstances
Yes, yes.
which must have a link and the such chain of events must lead to one conclusion
One
that
conclusion.
this is you.
Yes, your lordship.
Nobody can accept you.
Yes.
If that is not there,
Then-
then it's
From my side, it is dear Lord.
okay. That's it. No, this is the preliminary we are understanding.
Yes.
Okay.
So that is the and if the charge of forgery, your lordship, that falls, then the charge under section 468 and 420 will also fall, because 468 and 420 are directly connected.
Directly connected.
And then if that falls, then 120B, it has to lead to either commission of a legal act for illegal means through legal act through illegal means, or for illegal act. If the illegal act is the act of forgery, if that act of forgery goes,
Understood.
So
Now how to type out is all these evidences?
people have to go through the judgment. It has-
Judgment will go later on.
in the
See,
judgment,
moment will go, oh, that from judgment, that
Yes.
there is record.
everything is in a precise form, yes.
Is it present?
It is.
Have you
it
gone
is-
through it? How
It is
it is
recorded, Your Lordship.
recorded?
Every statement has been recorded in a very precise form. So you'll find, Your Lordship, whether there is illegality or not in the judgment itself.
So do you agree both parties that a recording of those with evidence will suffice, or instead of dictating?
In fact, Lordship, subject to what my learned friend says, if the evidence as is recorded in the judgment is followed, is recorded now, and then your Lordship specifically examines these witnesses that we have mentioned today, if special attention is, or
Yes,
this is
because these are the
scrutinized-
issues.
Yes, then perhaps that will suffice. But that apart, Lordship.
No, on hearing you on the each of the witnesses
Lordship.
and recording your arguments, there is no code. We'll do everything.
Lordship.
What is the anxiety is how many witnesses? 45.
46 and one defense witness.
46 witnesses to dictate in the court, not possible. It will take much time. So we'll start this work in our chamber from the judgment. Do you
Yes, yes,
disagree?
yes, yes.
Instead of dictating.
Yes.
If that can be done,
Not even required also because
Yes.
seizure witnesses are there.
Yes.
From PW1 to PW5, they are seizure witness basically. So I wrote in a more precise form here, but I will not.
you type it. You do
The
it.
Lordship will go through the judgment because.
I will go through the judgment.
Yes.
Okay. Okay, so
Every witness, yes, not each witness is equally important. Lordship.
not important, but as delivering, we are in a first appellate stage, na?
Yes.
While delivering, we'll have to record what who says whatever. Then we may say that these witnesses are not important, but we'll have to record it.
Yes.
We
Very difficult to understand.
no. What we are proposing is we'll just initially go through the evidences. We'll initially record it from the that portion recorded by the learned trial court. Is any difficulty, Mr. Focus?
The judgment has been delivered by Justice P.K. Soikia, Lordship.
Then it will be
Very precise.
that correction we did not have in it. Retrospect. Now, so let us conclude today. Anything you want to add?
No, Lordship. Because we
See, difficulty is this court bench may not be available next week. So we are fixing a date. In the meantime, we'll try to complete this portion. Okay. Then
Very
we'll proceed.
Right.
Okay. By the next date, you will also get I think you will also get a copy of the type copy of the evidences. Okay. Mosumi.
In addition to that, Lord, may I just make it clear?
Yes.
In addition.
Of course. If you are here and you want to argue, why not? We may not hear you when you are not here and seek an adjournment. That is a different proposition. But when a person is here, you want to argue, we'll definitely hear you. What if? What if?
21st and 22nd,
Okay, give a convenient date.
22nd, I'll go up to state.
Okay. Yes, we'll see the diary of the PP.
23rd holiday. Oh.
23rd is a holiday.
27, Lordship, we can fix.
27 already one fixed matter is Lalsan Agarwal Lordship, all pending matter Lordship.
27.
7 is already fixed matter. 29th is a Thursday. 29th is Lordship.
29th. Okay. List is heard the amicus at length. Full stop. Due to paucity of time, hearing could not be concluded. Full stop. List it for further hearing on 29th of August 2024. Now we understand. Now only job is to be done is that part.
Will it have to be reflected as part heard or?
Already. No, no, we'll finish it. This is matter is, I think for this 45, looking at this 45 evidences, this is the reason it's why it's pending.
Go through the PW6, your lordship will get
His
PW6 is
evidence
very
is
old.
most relevant.
He's a star witness.
Star witness.
And judgment is also 60 page manner, I think. And is of 60.
We'll finish it within 27 pages. 27, except those evidence.
Yes, sir.
Except those evidence, it will be 15 pages. Not 15. 2 pages, evidence minus 2 pages, 4, 2 pages, 8 pages.
Deeply obliged.
If I, it won't be done.
Lordship, I just want to make a suggestion. From tomorrow on, I will not be here. Lordship. If any matter listed, I have already informed the registry. I know.
May I please your lordship?
Yes.
I have discussed with my officer during break time. There's a progress is there, not only he, similar, a lot many petitioners are there. That is why lordship made a due letter. I was not for time period, only I'm sending. Honorable Minister, Union Minister returned to our chief minister to look into the matter. Accordingly, matter is progress is going on. Not only he, my lord. Similar issues are there. That's why I'll bring it there, a detailed affidavit if required, my lordship directs. No, any of the official, demi-official letter too.
Okay, we'll hear this matter on
Yes.
merit on next when.
If required, my lord, I'll file affidavit because thereafter one notification has
Okay,
come.
if you want to file affidavit, but 2017
Yes.
matter will fix, we are adjourning it today. And if you want to add something, you want to file an affidavit, you tell us when we should fix this matter.
2 weeks after.
2 weeks, okay.
2 weeks.
Date may be-
We'll fix a date.
Yes, yes, definitely, my lord. And may I pay for, because already I have filed an affidavit. Because
We'll just record that.
record that is a need petition by way of affidavit.
Okay,
Your observation is,
that's-
it will have for me, my
that-
lord, to
that's
file
fine.
affidavit.
Hey, Musu, itu file this. Itu file dari অৰুণাচলত হেৰিটো যাব এই ফাইলটো হা বাকী পাৰ্টটো ৰৈ যাব এই বস্তু আৰু যদি নহয় ইউ কেন ঠিক আছে এইটো চেম্বাৰ দিয়াচোন পিছত কথা চেম্বাৰ Mr. Borua, learned counsel for the petitioner. B. Borua, huh? For a petitioner. Mr. M.S.M. Borman, learned government advocate Assam for the state respondents.
For C Borua for respondent 6. NSA.
And the standing council and C Hills Autonomous Council for respondent number 2, 3, and 4. And Mr. C. Borua, learned counsel on behalf of
NSA. Standing council.
and standing council,
NSA.
C. Borua, standing council, NHAI, respondent number 6. The present petition is filed with a grievance that during construction of NHAI number 54, number 54, within bracket new NH27, the land of the petitioner has been damaged and they have not been paid any compensation for such damages. Full stop. Full stop. The
NHA.
respondent state has also supported the contention of the petitioner by filing an affidavit,
Yes,
filing an affidavit wherein
revenue, my lord.
revenue state just
Revenue for standing NC Hills.
okay, the revenue authorities of the NC Hills has also supported the stand of the respondent, petitioner, by way of a filing an affidavit. True,
So, my lord, respondent,
tell us the name. True,
so, my lord, respondent 2 and 5.
to respondent number 2 and 5,
Respondent number 4, my lord, I'm sorry.
respondent number 4,
Yes,
and they have also submitted a report
yes.
whereby assessment of damage has been made. Full stop. The National Highway Authorities has filed an affidavit and has taken a stand that it is the contractor.
My submission is this land in question is beyond the right
Okay,
of way.
Has taken a affidavit by has taken a stand by filing an affidavit that the land is question is beyond
Beyond right
the
of way.
right of way,
There is
and
ROW
the damage caused
by the
is by
contractor.
the contractor engaged by the National
Hence, as
Highway
per agreement between
authorities,
contractor
NHAI, and as per the contract between the NHAI and the contractor,
in question.
the contractor is liable to pay such damages, such damages. Therefore, the NHAI is not liable for pay such compensation. Full stop. Mr. Burua further submits that, like the petitioner, many other persons have filed applications before the authorities, the competent authorities in NHAI, for seeking damages, and already a committee has been constituted to look into the matter, and therefore Mr. Burua submits that he may be allowed to file an additional affidavit to bring such fact on record, if so advised.
Right.
Full stop. Full stop. Considering the above, the matter stands adjourned and be listed on. Tell us.
13 August.
13 others is early. After
28th of August?
yes, madam.
20, man.
28th
Yes,
of
yes,
August?
madam.
28th of August 2024, in the admission column,
For hearing.
for hearing. In the meantime, affidavit affidavit may be filed if so advised. 20. Yes. Mr. Just take.
Yes.
Otherwise, my lord, this, perhaps this letter will not support our case, man. It's a different context, man.
That is a context of NGO.
Yes, man.
NGO are claiming they
No,
may.
NGO is fighting for all,
All.
including him.
We have no instruction, man. I have.
He's not there,
Yes,
including
yes.
him.
Okay.
Oblige.
Anything left? Huh? You are NCLs. Okay. Now, C. Sharma, NCLs. Though we have written in standing council, but C. Sharma, Mr. Standing Council,